and posted on the municipal bulletin board on January 3rd, 2020. Please stand for the Pledge of Allegiance. There we go. You all ready? I pledge allegiance to the flag of the United States of America,
to the republic
for which it stands, one nation, under God, indivisible,
liberty
and justice for all.
Okay, we don't have any formal presentations. We do have minutes to approve from June 22nd. We have a motion for the minutes.
I'll move.
Second,
I'll second them.
all in favor?
Aye.
Aye.
Opposed? Okay.
I wasn't there, so I'll abstain from that one.
Okay. We now have an open session, so if anyone from the public would like to speak, if you go to participants and down at the bottom, it'll say raise hand. If you're on an iPad, I believe it's up on the top, but it should be a little thing that says raise hand and the icon will appear.
Is this the only open session for this meeting?
No, we have two, and then we also have we have a couple of public hearings in between.
Oh, right, okay.
I see the pod ones, but actually we have them on the agenda for later, so I don't know if they.
Yes, we have a public comment.
Okay. Very good.
Okay.
All right, this is Jean DePodwin. Hello, everyone. Old Colony Road.
Yes.
I see tonight that on the agenda, you are going to discuss making significant changes to the appeals portion of our town's tree protection ordinance. The motion appears on page 3 of the agenda as motion number 2020-1847.
Mm-hmm.
My husband and I are very concerned that the proposal to amend the ordinance will, in fact, water it down and weaken adjacent property owners' rights. And why now? Why is there a need to change the ordinance tonight? Ironically, there is an appeal from us that is now on the agenda this evening, item 10A, and it directly relates to this ordinance. It concerns our objection to the granting of a tree removal permit by the Shade Tree Committee to our neighbor who plans to cut down a healthy 70-plus-year-old red maple tree. We find the timing of this motion, 2020-1847, and our current appeal to be very curious and concerning. Given the proposed amendment, will our appeal ultimately have standing? We don't believe that this body, I heard a yes. Was that a yes?
Yes.
Okay. Great.
This does not affect your appeal at all.
Okay, thank you for that. Then I would like to finish with why we think what these proposed changes would do to the tree protection ordinance. Number one, we think it will eliminate the ability to appeal to a second level authority, leaving the final decision on all tree removal appeals to only the Shade Tree Committee. This is the same committee on which the tree conservation officer serves and who grants the initial permit. With the proposed change, this same committee would then be expected to objectively hear an appeal on a permit that had just been granted by their own TCO. This seems very one-sided to us and inequitable. Number two, the changes would deny property owners' right to a fair appeal process with appropriate checks and balances by the council or other governing bodies such as the Environmental Commission. And then finally, number three, the changes would eliminate the current requirement to notify adjacent property owners within 200 feet of the subject property. This would eliminate nearby property owners' current rights to be informed and protect their interests. We therefore urge the council to leave the existing tree protection ordinance and appeals process intact and enforced. Thank you for your time and consideration.
Thank you.
We'll send a copy off to Anthony later this evening.
Oh, great. Thank you.
You're welcome.
Did anyone else from the public wish to be heard? I don't see.
Hello, my name is Marla Jennings. I'm the tree owner. Unfortunately, I did not hear the start of this meeting. My audio was not working on my computer, so I'm on via telephone. So I missed the beginning of the Department discussion. However, I just wanted to say that I am surprised that I am here for a tree that is on my property, that I went through the appropriate course of action to take down, and I got the appropriate approvals in the correct way. I do believe that I have endured a lot of stress over this. I believe that the Podwins are looking for a deed restriction that did not exist and does not exist.
Okay, Marla, if I can interrupt you, we're going to have a hearing on this later in the meeting. What the Podwins were speaking about was about an ordinance change that we're making.
That's right.
So,
Okay.
yeah, so later on, we're going to have a formal hearing where you can each give your side of the situation.
And then when will the decision be made?
I believe we have to do it tonight or within 30 days. I forget, Jack.
You have 30 days. I would hope we'd be able to do it tonight.
Yeah, but it'll be on the agenda further along. We'll actually have a formal hearing where you can each both state your case.
Jack, when does the 30
I'm
days
sorry,
start
I didn't
count?
realize.
No, that's fine. It was confusing.
Jack, we have 30 days from what date?
From tonight.
Okay. Did anyone else from the public wish to speak on anything? Okay, then I will close the public session. And I will open a public hearing on Ordinance 2020-1843, an ordinance concerning uses permitted in the industrial district and amending Chapter 12 of the Borough Land Development Code entitled Zoning. Would anyone in the public like to be heard on this ordinance? Seeing none.
Did we make comments or questions before we vote?
I see there is a hand up.
We have a hand raised.
Oh, we do have a hand raised. Sorry, I see Nicholas.
Nicholas, yes.
Oh, hi. My name is Nicholas Pompilio. I'm from the law firm DeFrancesco Bateman for the borough of Bar Hills. I would just like to put a public comment on the record before you guys take a vote on the ordinance. That's all right?
Yes.
Yeah.
I just wanted to make sure you could hear me. I'm sorry.
Yeah. It's a little fuzzy, but we can hear you.
Okay, thanks. I'm just gonna take a look at my notes here, but thanks for the opportunity. And again, I want to, we represent the borough of Far Hills, and we would just like to submit a formal objection to the, on behalf of the mayor and the borough of Far Hills and its residents to the proposed truck route from the quarry property at issue with the Bernardsville Ordinance 2020-1843 in connection with the Old Quarry Road Associates LLC application. The Borough of Far Hill does maintain its prior written objections to the preferred truck route set forth in the ordinance, as the route, in our opinion, will create a safety and traffic hazard in the Borough of Far Hills by sending a considerable number of very large trucks through the heart of Far Hills. The ordinance allows the quarry to be utilized as a recycling facility, as you know, and it sets forth truck traffic limits and further provides that trucks leaving the transfer facility will proceed south on Route 202 through Far Hills, which is the portion of the ordinance that we object to. The recommended truck route to the facility, I guess, requires the trucks to travel Route 202 south, and by incoming trucks coming to the facility this way, they don't go through Far Hills. However, when trucks leave the facility, it's my understanding through the ordinance that they'll be traveling Route 202 south through Far Hills, so continuing through the borough, and that is where our objection centers on. In addition to general and safety concerns, we do have some specific comments I'd just like to put on the record briefly. There's a bridge reconstruction in Far Hills, Route 202 South in Far Hills near the border of Bedminster Township. That bridge is going to be taken down and rebuilt in the next few years by the DOT. In the course of that construction, the bridge will be closed for approximately 6 months to 2 years, and it will force many alternative routes for the residents, busing, emergency services through the town. None of these routes could accommodate any commercial traffic, let alone the truck traffic that we anticipate. So one of the issues, specific issues, is the bridge in Far Hills. Another specific issue are the elementary schools. There's numerous elementary schools and residents on the proposed truck route to South and Far Hills. The Country Day School is one of those, for example. In our opinion, the proposed truck route regulates trucks anytime between 6 a.m. and 4 p.m. Monday through Friday, and this is during drop-off and pickup times. We believe it presents an unnecessary danger to the children. Another specific concern we have is the railroad crossing in Far Hills. The proposed truck route would pass over the railroad crossing, and it's not only just a railroad crossing, but it's a location of the Far Hills train station. There's a good amount of pedestrian traffic at this location. In addition to simply being a railroad crossing, our position is the truck route creates a potential safety hazard, having approximately 34 trucks per day across the railroad track area. Two other specific points. The Far Hills does host some of the largest events in the state, being the Far Hills Race Meeting and the VNA Charitable Sale. These events invite a significant number of attendees through the borough, traveling by vehicle, bus, and train, and mostly along Route 202. And the proposed truck route, in our opinion, will introduce approximately 34 trucks to this main access area for these events, will create a further safety hazard. And lastly, this stretch of Route 202 in Far Hills South, the proposed truck route, it's a scenic corridor which has many narrow sections, small bridges, and our position is this section of Route 2 is just not a safe section of roadway for normal traffic, nevertheless, except traffic coming from the quarry. Accordingly, Far Hills strenuously objects to the subject ordinance based upon the proposed truck route for the reasons stated for trucks leaving from the facility. The ordinance will allow approximately 34 trucks per day, 6 days a week, to leave the facility and travel Route 202 south through Far Hills, which the borough believes to be inappropriate and unsafe. Rather, Far Hills respectfully requests that the ordinance require truck traffic leaving from the facility to travel north on Route 202 through Bernardsville, turning right onto the very short section of North Maple Ave through exits 30A, 30B onto I-287. I believe this is the same way the trucks would be entering the facility is the way we would like trucks to exit the facility, as opposed to going through Route 202 South in Forest Hill. Based upon that, we do respectfully request that the borough not approve the ordinance as written. We do appreciate your time for letting me put the objections on the record.
Thank you. I don't believe, Jack, maybe you can help me with this. The ordinance itself does not specify the route, does it? That's
correct. We cannot control the routes as long as they're legal routes with no weight limitations.
Okay. But yeah, what the ordinance is really about the uses in that particular zone.
That's correct.
Okay, I didn't know if it was actually in the ordinance or the settlement agreement, but I did think there was some discussion previous to now of truck routes coming to and from, and if that's part of the ordinance, we just wanted that objection on the record.
Yeah, no, I appreciate that. Thank you.
We do encourage them to go south on 202.
Okay. Is the council have a position on whether the traffic is traveling from the facility on Route 202 south, or my understanding is that is where the direction of the traffic leaving the facility would be, correct?
I think it depends on what their destination is.
That's right.
They wouldn't all be going, it depends on which way, where they're, what recycling facility they're going to from there.
I understand.
The only truck routes that are mandated by the county have to do with I think there are 4 trips a day taking away the waste from the site. But that's up to the county. The borough has no control over that either.
Yeah. But thank you. We do appreciate your concerns.
Okay, thank you.
And I believe you sent us a letter with those as well.
We did, ma'am, yes.
Thank you.
Thank you.
Does anybody else want to be heard on this ordinance?
I have a question for Jack.
Sure.
The part of the the settlement agreement was that they would build a bridge over the stream to facilitate a safe transit of children playing on the playground there from the parking lot.
Yes.
What happens if the DEP does not grant approval for that?
That will probably prevent it from happening. We'll certainly support the application. And I think DEP will approve it. It may take some doing on their part from an engineering standpoint, but.
Well, okay, is their development of the transfer station contingent upon the satisfaction of that part, which was an important part to all of us because it dealt with the safety of the of kids playing at the Rose Bowl. So they go ahead and build the transfer station and take 10 years. As I'll give an example. Take 10 years to get the DEP approval.
I understand your concern, but that's part of the settlement agreement. This ordinance does not deal with that in any way.
Not related to the ordinance again.
I know, but it was part of the packet was the settlement agreement, and it made me think about it as I was reading it because when it talks about the stream, there is no timeline saying that they would do it within some set period.
Okay. Anybody else have questions or comments?
So sorry, Jack, I didn't get your answer then. Is there no deadline? They could just drag it out? Like the settlement agreement allows them to just do it and delay it indefinitely? Or would they be prevented from opening until they satisfied that portion of the settlement agreement?
Yeah, I think they have to do it within a reasonable period of time. And the expectation is they will do it concurrently with their application with DEP to open the facility.
Well, let me put it this way then, because my understanding was that there was a certain monitoring period. I think it was a year, that if they had any violation of that in terms of the number of trucks, then we could go back to court and could potentially void the agreement.
Yes.
If they haven't made any good faith effort to get the approvals, would that also hold true?
Yes.
Okay. And I just for the record want to say, the ordinance talks about how this is it's kind of funny worded with a kind of a double negative. It talks about how it's not inconsistent with the master plan. I realize we're locked into this ordinance, but I object to that language.
Yeah, Jeff, I can speak to that, Jeff. That's actually the official language that the planning board uses, as wonky as it is, for saying something isn't that they agree that it's in line. It's a double negative, but that's the language they've used in multiple places.
Let me finish. I'm objecting to it. And I want to be on the record because I don't think it is part of our master plan. And I don't think that if we were to have this vote today, anybody else would think it's part of the master plan. And I can tell you this council wouldn't think it's part of the master plan. So I'm just objecting to that sentiment.
I'm sorry, Jeff. I thought you were talking about the language itself, which is what you were questioning.
I can tell you the language itself comes directly from the municipal land use law. And that's the charge to the planning board, is to determine whether or not the ordinance is not inconsistent with the master plan. I agree, it's awkward language.
I'm not
making is that it's not. You don't think it is consistent with the master.
Yeah, I understand the substantive point.
Yes. The language is awkward. That's not my point. The point is that while we made a settlement, I don't agree that this is consistent with our master plan. So I just want to be on the record for that.
Understood.
I agree with Councilman Hammond.
Okay.
Sorry, Mary Jane, I had a question about this ordinance as well. Is now the time or later before we vote?
A question on the ordinance?
Yeah.
Yeah.
Just in relation to the monitoring of the traffic, as Councilman Hammond brought up, we had talked about enforcement of that and putting together some kind of committee or something that was going to work on enforcing and what we were going to need to do there. So has that moved forward at all?
No, we're nowhere near that. Right now, they're still waiting for DEP to approve this project. I mean, it may end up that they never even get approval to do this. But until they actually are approved, nothing is happening. Nothing will happen. I'm sorry, Jack, is that correct?
Yes, that's correct.
So our enforcement of this, I think, is going to take some time for us to figure out, as in most things with government. So how can we figure out, kind of get a good plan together so that we have enough time so that when it's there and it starts to happen, our plan is in place and we're not trying to play catch up.
So at the first step, Gina, what I think we should do so this is a lot of this enforcement, at least part of it's going to come, in my opinion, with Jeff and the zoning enforcement group. We should take this up immediately at our next meeting with zoning enforcement. I think that's for me an immediate first step.
I agree.
That would be great. I just don't want to lose it. And I feel like, we talked about it a lot and there was a lot of public opinion about the enforcement.
Yeah.
And there was, lots of requests for it. And so I just don't want it to be something that falls through the cracks.
Yeah. Well, I think the question is, so if we do that at a minimum, right, that has to happen regardless. Do we want something in addition to this? I guess is the question you're asking, right?
No, for me, my question is, how are we going to enforce it and who's going to take responsibility for it so it doesn't fall through the cracks, whatever the timing might be. If mayor is saying, we're far out from that, that's okay. But I just don't want it to fall through the cracks and then it come through and all of a sudden we're okay. The DEP's accepted their application and now they're starting, in a month and we don't have anything from an enforcement perspective in place.
May I speak?
Yes, go ahead, Jeff.
There's one important part about this, and that is that it will require planning board approval. So once the DEP have said, okay, they need to get their plans together and go back to the planning board for their approval. And it's at that point there where you can add these conditions from the settlement or from wherever into that resolution.
Oh, that's news. I didn't know it had to go back to the planning board again. I thought the planning board already approved it.
I think the original construction part of it.
They'll have to get site plan approval.
Yeah, site plan approval is something the planning board do.
Correct.
Okay.
So I have an additional comment. Councilwoman McCready, I agree with your approach that we need to be prepared and not wait to the last minute and find ourselves, behind by a month or three with the approach. So I agree and support exactly what you just said. And Councilman McQueen, bringing it up, I think in the zoning meeting is also appropriate. But I was approached by one of our constituents as well, and they were talking about how they can be involved in the DEP process, which does not happen in our borough, but happens in the state at a state level. But borough members, constituents have concerns, interests, they have input, and some have expertise in the area. And I think that we need to at least communicate what the process steps are and provide guidance to constituents who wish on their own accord to be involved in the DEP process and evaluation of the application. So what can we do? And maybe this would be, forming this committee ahead of time, Mayor, to provide at least a communication path to illustrate to our constituents checkpoints in the process and who's involved in that process, contact information for the appropriate people. If those people, and this is not a borough action or activity, our action is to just communicate to the constituents what the process steps are, what the timing is, and who the players are. And I think that, we have a responsibility to make that information public on our website, for example, so that people don't feel like they're out of the loop on the DEP approval process. And I know, at least one constituent has approached me and said, how do we get involved? Who do I contact? I have input and ideas about this, and I want to be involved in the DEP process. And that's not our process, but I think we need to communicate to them where the process steps are and who the players are.
I think we could do that as long as we don't lobby people to object to the process. Since we
Not at all. I'm just saying communicate the timing, the process steps, the offices that are involved, the contact information that, this is, if people are, decide to be involved on their own, we're not telling them what to do. We're telling them who to speak to and, when they need to, if there's a deadline, for example, of November 15th for something, that's just a made up date. But that, as for an example, we should be communicating those process checkpoints and make it the process as transparent as possible for any members of the public who choose on their own accord to be involved.
Jack,
Great idea.
do we get information from the DEP as to that process? I mean, would we know what their steps are, or do we have access to that information?
Yes, or we could ask the Curtis firm, since they were involved in the DEP process, what the next steps are. And I think we can do that as long as we couch it in terms of if you'd like to be heard, as opposed to if you would like to object to the application.
Right, as a matter of staying informed.
Yes.
And yeah, access that, and then we could publish this schedule on the website as to what the steps are. Okay.
Yes.
So just to confirm, we would be able to say, if you have a comment, yay or nay, pro or con, here's who you contact.
Yeah.
Correct. We could say, if you'd like to be heard before the DEP, here's how you do it. As opposed to if you want to object to, or we encourage you to object to their application.
Right, and that's just to be clear, I didn't suggest that. What I was suggesting that we have a process that's transparent and people know who to contact if they so choose to be involved. And that's the information I propose that we share.
I understand. I just wanted to clear on the record.
Councilman O'Day.
Pardon?
I like the transparency.
Yeah.
Good approach.
Okay, would someone like to move the ordinance?
I'll move it.
Okay.
I'll second.
Okay, just read the line, John. I move to pass ordinance 20.
I move to pass ordinance concerning permitted uses in the industrial and industrial district.
Just the line down.
I'm sorry. I move to pass ordinance 2020-1843 on final reading and adopt as published.
Excellent. Thank you. Do you have a second?
Yeah, I'll second it.
Okay, roll call, please.
Mr. Donahue?
Yes.
Mr. Hammond?
Yes.
Ms. Reedy?
Yes.
Mr. McQueen?
Yes.
Mr. O'Day?
I want to make a comment before I give my vote, but this process has backed us into a corner. We have no choice but to do this from a legal perspective. I would have been against this from the start. I feel that we, this council, have been put in a position that's not tenable from a legal perspective, and therefore I'm forced to vote yes, but I'm totally against this project, this process, and the approach that was taken in the past.
Ms. Zamara?
I vote yes too, just to save ourselves the legal cost of fighting.
Okay. I will open the public hearing on ordinance 2020-1844, ordinance of the Borough of Bernardsville, County of Somerset, New Jersey, adopting the redevelopment plan for block 125, lot 13, as shown on the official tax map of the Borough of Bernardsville pursuant to the local redevelopment and housing law, NJSA 40A 12A-1 at SEC, which was the former Audi site at 65 Morristown Road. And before, I'd like to invite Chris to share he has a review of what we went through to get to this point. So I would like to invite Chris Colley from Topology to show us how we got here.
Cool, thank you, Mayor. And I'll be brief. I'm going to share my screen. Okay. All right, so as I said, I'll be brief. I'll only speak for a few minutes, but my name is Chris Colley. You've seen me a couple times now. I'm a redevelopment planner with Topology. We prepared this redevelopment plan on behalf of the borough with input from a variety of borough stakeholders. Just a little bit of a quick timeline. Back in December of 19, we went through the process to have the site designated in need of redevelopment. Roughly from February to May of 2020, we worked with the Downtown Redevelopment Committee, which has members of this body, members of the planning board, members of the public on it, in producing this redevelopment plan. The Borough Council, back on June 7th, introduced this ordinance. Subsequent to that introduction, we went to the planning board, where the planning board found it to be not inconsistent with the master plan. Planning board also asked us to provide you a description of areas where this plan differs from the pending downtown zoning ordinance that they've been working on, and we'll get to that in a moment. And then today's July 13th, second reading and potential adoption, public hearing on the ordinance. So you all know the site by now, 65 Morristown Road, a little under ½ acre, former Audi site. Site is currently zoned for a C1, which permits a variety of commercial uses, 2 to 3 stories of development, a density of 25 units per acre. And it's really been our job in drafting this plan to come up with zoning and the redevelopment plan that was going to result in a project that the borough wanted, and also a project that was buildable. So I won't read this out loud, but this is sort of the vision that we put into the plan. You'll note vitality of downtown Bernardsville, improve the public realm, high quality architecture. And we also put into the plan some terms to sort of incentivize the creation of a mixed use building with ground floor restaurant or retail. So again, I won't read all these out loud. I will point out that upon introduction of the ordinance, there was comment from the council about including an arcade as a permitted use. We did incorporate that into the final copy that was introduced, but permits a variety of building types, mixed use, different commercial uses, some community uses as per input from the council. And then it also specifically prohibits a whole host of different uses. Any use that's not specifically permitted is prohibited, but we went that extra step to list out some of these prohibited uses that's included in there. In terms of like the build out of the site, and again, none of this has changed since the introduction, but we wanted to put it out there for the purpose of the public hearing. Building coverage of 55%, 60% if you have a mixed use building with ground floor retail and restaurant. Setbacks designed to orient the building towards the street, keep it close to the street, but also allow for an area, sidewalk, ample sidewalk, as well as a sort of outdoor seating. We're calling interstitial spaces in front of the building. Maximum height of 3 stories, 35 to 40 feet, depending on where you measure it from. And then residential densities of 30 units to acre to 35 if the bonus is used, the bonus which you would get for doing a mixed use building with a ground floor retail or restaurant. That translates to like 13 units with no bonus and 15 units with a bonus, just for the purpose of speaking in clear terms. We have parking standards in there, of course. Importantly, the parking is required to not be in the front yard. The site is sort of like, we think, a transitionary area between core of the downtown and this corridor of 202 that you see as you move further away from downtown. So we thought it was important to make sure the parking was not in the front yard. There is language in there about on-site shared parking, off-site shared parking, some tandem parking spaces, all sort of designed in a way to try and maximize the site and get the best layout possible. Just some other things that are in the plan. The great thing about these redevelopment plans, you can put in as much or as little as you want. So we have what we think are pretty detailed streetscape improvement standards about sidewalks, lighting, landscaping. The sidewalk area, as I mentioned earlier, the sort of seating area, interstitial space in front for landscaping, outdoor dining if there's a restaurant, things of that nature. We have architectural standards in there, which deal with materials, massing, things of that nature. Again, trying to like orient the building towards creating more of a downtown feel than like a sort of strip mall feel. Detailed site design standards about lighting, landscaping, parking, etc., signage. Traffic impact study. So another one of the changes that came out of council. It's in there, but planning board has an opportunity to waive if they see fit. And affordability required on site in compliance with the borough ordinance. So what we've done since we saw you last was we went to the planning board. We did, I think, a pretty detailed review of the borough's latest master plan, as well as the borough's latest master plan reexamination for consistency or non-inconsistency. As I said, the planning board did send you back a resolution with their finding that it was not inconsistent. But importantly, they did flag for us, this fact that they've been working on this downtown zoning code for a while, and they just wanted to make certain, and I'm not sure if there are members of the planning board on the call, that any differences between the redevelopment plan and the pending downtown zoning were identified so that you were aware of them. So what we did is we did our best to identify any differences, and I think that I want to couch each of these in the context of, when you do zoning, like you do zoning for a broad area, and when you do a redevelopment plan, you're really writing standards specific for one property. So it allows you, to get much more fine with your details. So just to highlight some of the changes, front yard setback is a little higher here in this case than it is in the downtown zoning. And that's really to create that extra space for that outdoor seating area in front. The location of where the setback is measured from is from the curb in the plan. It'll be from the lot line in the zoning. Thought that was important because of we just really want to make certain that in this particular property we have the exact amount of space from the curb that we would need to satisfy the plan. Side yard setback's a little different. Again, this is sort of a site-specific thing about how we would envision circulation happening. Rear yard setbacks, again, are sort of in between the two options in the downtown zoning. Interestingly, the height in this redevelopment plan is slightly lower than what it would be on the pending downtown zoning ordinance. And the rationale for that really is in that pending downtown zoning, it breaks the downtown up into, I think, 4 sub-districts. This site is in the downtown core, which, as you see, has 40 to 45 feet height, but it's also the last property in the downtown core. So it was sort of convenient and I think helpful that we're doing a plan on this site, because we were able to sort of pick an intermediate height, slightly taller than the downtown corridor, slightly smaller than downtown zoning, that creates a transition. I'll bang through these last few kind of quickly, but we are more restrictive in the property uses. So again, when you do like a broad brush zoning, like you want to have, I think, sort of be more permissive because you don't know necessarily what would be on each site. But in this case, we have one site, so we were able to be pretty restrictive in terms of uses and in terms of what the borough would want to see. We also got specific in terms of units per acre to make sure that there's no sort of like runaway development, more specific in terms of building coverage, and a little more rigorous, I think, in terms of stormwater management. One thing that we are slightly more flexible on is in the downtown zoning, there's a lot of details about like building attachments, chimneys, and things of that nature. We're not quite as detailed there. And, I think that kind of makes sense in the sense that if you adopt this redevelopment plan, you will have in front of you, prior to any project happening, a redevelopment agreement. And that redevelopment agreement, it's a requirement of the plan, will have detailed drawings and building elevations and things of that nature. So it's really an opportunity to make sure that someone works within the framework of the building design standards that are in the plan, but gives you, the council, sort of a second bite at the apple for the specific detailed building elevations. So that's it. That's all I have to say. I'll answer whatever questions you might have for me. And if you don't have questions for me, I'll just sit quietly and allow you to talk amongst yourselves. So thank you for listening. And
thank you, Chris. I think it was really a worthwhile process to go through. I mean, the committee did a good job working on this, as well as topology. It's a very odd lot, so I think we came out with a good plan. Does anybody have questions, either from the public or the council? The hand go up again. The Podwin.
I saw Terry Thompson's hand go up, and no.
Terry's was up first. Okay.
Yeah. Okay.
I just want to thank Chris for the time he spent on this and working with the planning board. I think we got a much clearer understanding of where he was going. And Chris, if you haven't already shared your last slide with Frank for us to see that you did what you were asked to do to compare the two, I'd appreciate it if you would.
I'll do that. Thank you.
It's a good plan. I'm very happy with this. Thanks, me personally, I'm not speaking for the board.
Okay, and then I see the DePodwin's hands up.
Yes, hi, this is Dave DePodwin. Yes. I may have missed this, Chris, but one question. Is it known whether any DEP remediation is required on any part of the site, given that it was an auto dealer and one before that as well, I believe?
Yeah, we know a little bit about that in that there was an RAO that was issued on the site, which I believe had to deal with closing out of an underground storage tank. Whoever chooses to redevelop the site, like, they're going to have to do their own environmental due diligence to confirm that's the extent of the issues, and they'll be required to do whatever DEP requires them to do to bring it to the standards of the uses that they choose to pursue. But from the information that we have about the environmental condition, it's my understanding that what is known has been addressed.
Great. And a second question, my last question, I just want to make sure you received a letter I had sent to the mayor and council urging the consideration of a pocket park. I sent the letter on December 26th as an idea that I first floated to the Bernardsville News on June 10th and then on November 19th. And then I followed up with a summary letter to the mayor and council on December 26th. So I wanted to make sure you got that letter regarding the idea for, given that we have enough brick and mortar and we need more green space, and given the traffic issues there and the density, that green would be highly valued in many different ways. And my letter December 26th showed that. I wonder if you received that letter.
I believe so, and I
recall receiving it.
Yeah,
Yes.
I can tell you confidently, park is a permitted use under the redevelopment plan.
Yeah, it's on that list of permitted use. We did put park in there.
Yes, thank you.
Yeah.
Great.
Thank you. Any other questions for Chris or about the plan? I don't see any. So I will close the public hearing. Councilman O'Day, why don't you move it?
Yeah.
I'm sorry.
Oh.
Go ahead. Did you have something, Chad?
Oh, yeah, no, I didn't know who you wanted. It doesn't matter. You can go ahead if you want. It doesn't matter to me, or I can move it. This came out of the planning board, so why don't I do it? I move to pass ordinance 2020-1844 on final reading and adopt as published.
I'll second.
Roll call, please.
Ms. Zamara?
Yes.
Mr. O'Day?
Yes.
Mr. McQueen?
Yes.
Ms. McCready?
Yes.
Mr. Hammond?
Yes.
Mr. Donahue?
Yes.
Okay, thank you. Thank you, Chris. And we'll see you tomorrow night.
Okay, thank you very
Yeah,
much.
I'm excited to move this forward. It's an area that a lot of people in the public have mentioned as a opportunity for us. I hope we can capitalize on it.
Agreed.
Okay, thank you. Bye.
Councilman McQueen, would you like to move the introduction of the next ordinance?
Sure. Do you want me to provide an explanation, Mayor, or just move the ordinance?
Move it first, and then we'll talk about
Sure.
Sorry, isn't this just introduction? It's really, do we discuss it at the introduction or we discuss it at the next meeting?
You can just, I mean, if you just to give an explanation, I think.
Sure. Okay.
Sure. So I move that ordinance 2020-1845, an ordinance amending the Borough Property Maintenance Codes in their entirety and supplementing and amending Chapter 11 of the Borough Code entitled Property Maintenance, be introduced by title and passed on first reading, published according to law, and that a public hearing be scheduled for a meeting beginning at 7 p.m. Monday, August 10th, 2020.
Second.
Okay, you want to explain it to us?
Yeah, so just a little bit of background. So initially there was two separate ordinances that covered both maintenance as well as many of the other enforcement items that we have, and they were I think they were from the late 90s. So this ordinance actually, it began with Councilman Hammond, and actually Councilman Hammond spent a lot of time on this, working also with Jack and the zoning enforcement group to combine both ordinances, to modernize them, and to try to provide clarity so that that way they're more easily enforced. So you'll find a lot of language, a lot of clarity, but importantly, two ordinances have been combined to make this easier to enforce and hopefully better for our borough. I don't know if there are any questions about the ordinance themselves. We can not talk about the specifics.
Thank you. Jeff, Jeff Price, did you want to add something?
Well, only that we met Jack, myself, Renee, Chad, and Diane Greenfield to review the property maintenance ordinance of an adjoining borough, which was relatively new. So what we did, we took the best pieces of their new ordinance and customized them and put them in our ordinance. And what I think we have here is an enforceable product.
Yes. There is one remaining item which I'll ask the council's permission. So one of the issues that we have currently with enforcement is actually getting pulled through completely through the court system. There's a minimum that if you go to our individual pieces here, it's on page 32, I believe. So this is it's a minimum and maximum fine of $100. Now we explored and discussed for quite some time. It was actually a discussion over weeks about increasing that minimum maximum fine, which we cannot by law. So what I'd like permission to do, either myself or Mr. Pigeon, is to speak to the court prosecutor to talk about how important enforcement of this particular ordinance could be and should be, and ask them to enforce it as strongly as possible.
I see Terry shaking her head. I think that since the council is actually charged with enforcing the ordinances, they can't tell the prosecutor how to do his job, and we certainly can't contact the court, but I think we can let the prosecutor know that this is a very important ordinance from the borough's perspective.
For clarification, you said minimum maximum, but I think it was the maximum minimum fine that we're allowed to charge.
That's right. Yes. Which is $100 by state law.
So we can't go over that number for the minimum fine.
That's correct.
That's correct. Now, we did, just so you're aware, things such as secondary re-inspections, places where we could alter the pencil, and so the fee that's charged for re-inspection and such, we did to the maximum allowable, but this is an area that we cannot influence. Did I say that correctly, Jack?
Yes.
Okay, thank you, Chad. So you moved it. Did I have a second?
Yeah, I seconded it.
Okay, so all in favor?
Aye.
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 Opposed? Okay. Jeff Hammond, Councilman Hammond, why don't you introduce the next one? I guess this is a public safety thing. Parking.
And it's library as well, actually.
Yes.
I moved that ordinance 2020-1846, an ordinance concerning parking in the library parking lot and amending Chapter 8 of the Borough Code entitled Parking Lots and Off-Street Traffic Regulations, be introduced by title, passed on first reading, published according to law, and that a public hearing be scheduled for a meeting beginning at 7 p.m. Monday, August 10, 2020.
Do you have a second?
I'll second.
Okay. And this is largely, we're adding parking spots because we're moving recreation over to the downstairs of the library. Is that correct?
That's correct. This is an allocation of, I think, 3 additional spots for the recreation department.
The recreation staff. Okay. Any questions, comments?
I think it's a great idea.
Yeah, it's a nice space for them. I think that was it. It allows for social distancing and it gives them their own space, which is good.
And so camp registrations will be down there too, right?
Yeah.
I think that's great.
Yeah, it's a lot easier for the public to get in and out too.
Mm-hmm. They can walk.
All in favor?
Aye.
Aye.
Opposed? Okay. Now this is the tree protection. Who's on our shade tree?
I am.
Okay, would you like to introduce that?
I move that ordinance 2020-1847, an ordinance concerning tree removal permits and amending Chapter 13 of the Borough Code entitled Tree Protection be introduced by title, passed on first reading, published according to law, and that a public hearing be scheduled for a meeting beginning at 7 p.m. on Monday, August 10th.
Do we have a second?
Second.
Okay, so part of this, the change, and we had a question on it from the departments earlier. I believe, Jack, this was your suggestion that appeals probably shouldn't come to us. But what is the next step if we remove that piece? Where does the next step go for an appeal?
Any objector or applicant would go to the court just like they do for a zoning or a planning.
Okay.
Approval.
It would simply eliminate us having a hearing.
That's correct. It streamlines the appeal process. And I know the Departments raised the point about not having to give notice to all property owners within 200 feet. That seemed like an onerous requirement for this kind of thing. It still does require notice to abutting property owners.
And why would that be considered onerous, Jack?
Just for this kind of permit, the people that are directly affected are the people next door. You know, you can leave it at the 200 foot requirement if you wish, which is the zoning ordinance requirement or the MLUO requirement.
And remind me the rationale. I mean, I remember that we felt that it didn't really need to come to the borough council, but it also going to court there's some sort of background noise. I think somebody needs to mute. But that seems like a burden as well to go to a court. What's the objection to having it come to the borough council? We would be the next step. For example, if this was an appeal to the planning board or the board of adjustment, wouldn't that come to us?
No. The only planning approval that comes to you is the appeal of a granting of a use variance, a D variance. Site plan approvals, subdivision approvals, none of those go to the borough council. They go directly to the court. So this just seemed more consistent with the MLUO requirements, even though this is not a zoning ordinance per se.
Right, but the person who's doing our shade tree adjudication is also the zoning enforcement officer. So it's an analogous situation.
Oh, it is analogous, but legally it's not a zoning ordinance because it's been upheld as a general police power ordinance as opposed to a zoning ordinance, which eliminated a lot of the technical problems.
Okay, thank you.
May I speak?
It's not a public session at the moment.
Okay.
Sorry.
The public hearing is on August 10th, right?
That's correct.
Yeah. This is just the introduction. So. Okay. So we're introducing it. All in favor?
Aye.
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 Any opposed? Okay, so we will have a public hearing at the next meeting.
And there is a public session at the end of this meeting before it gets closed, correct?
Yeah, there is another public session at the end. Yes, yeah. Councilman Reed. So now we have, I don't know, who wants to move the next one? This is kind of a legal matter. So anyway, John, why don't you do it?
Okay, I move that ordinance 2020-1848 authorizing the acquisition by purchase or condemnation of the real property located at 210 North Findlay Avenue, Block 175, Lot 25, Bernardsville, New Jersey, now owned by Ultimate Realty, Inc., be introduced by title, passed on first reading, published according to law, and a public hearing be scheduled for a meeting at 7 p.m. Monday, August 10th, 2020.
Second.
Okay, Jack, you want to just give us a quick on that, or?
Yes, our affordable housing settlement agreement with the Fair Share Housing Center included a number of components, one of which is 100% affordable senior citizen development at this site. The settlement agreement goes on to provide that we will acquire title to the property by eminent domain if necessary. So this is just a procedural step that allows Marizzi Falcon, who we retained to deal with this acquisition, to negotiate with the property owner, but if that is unsuccessful, to take the property by eminent domain. But we're just following the procedural steps, and we're still optimistic that we'll be able to acquire it through negotiations.
Okay. All in favor?
Aye.
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 Opposed? Okay, I think we're good on that. Now we have resolutions, 2180 through let's do 2190.
Yes.
So any that you want to discuss before we do anything with them?
Yeah, I have a question about 20-185 and 20-189.
Okay, your question on 185, I believe the reason we got that back is there is a new standing judge who wanted to tweak the document some more.
Right, but my recollection was there was a clarification we needed as to how many days a month we had. The language that we considered before was unclear, and I don't recall seeing that. I went through the document, rather lengthy document, and I didn't see that in there.
We got that last time.
But I thought Bernards Township dropped out for this year.
No, we had approved this and signed it. We got all the information about what the hours were going to be and how many days. Do you remember that? And then we had all approved it, but then they changed standing judges, and it's just a language tweak that she wanted certain language in. If you look at the copy there, it's redlined what she changed, but we had already approved this.
Okay, I didn't recall that we had approved it. I thought we were still waiting to hear, but okay, I must have forgotten. Okay, thank you.
I thought I saw in the newspaper this week that Bernards Township opted not to join the Bedminster court system this year.
In the Bernardsville News?
In the newspaper, I thought I saw that just this week, an article saying that Bernards Township opts not to join. Am I wrong?
I didn't see that. I'll look.
I didn't see it. I see Charlie's here. Can you confirm or deny? No? Okay, I didn't see that either. So
there's an article about it on July 11th. It says Bedminster Shared Court with Bernards Township delayed. So give me a second if you want.
Well, I think that's why it was delayed. It's because this judge changed the language when it got her. Yeah.
Okay, it says.
I can't log in.
It says Bernards Township drops quest to join Bedminster Shared Court.
What is the date on that?
It says, oh, that's November 12th, 2019. Sorry, that's old.
Oh, yeah, they've changed their mind since then.
Yeah. Okay, we're good.
Sorry, my mistake.
Okay.
And Jeff, to answer your question, we had originally just Tuesdays, and they were adding Thursdays for Bernards Township. They were thinking they needed another half day, but
Okay. I remember that now. Thank you. But I didn't see that in this document. Did I miss it? I mean, I read it through it. I didn't see it.
I don't know if it's actually.
Days were in the agreement specifically.
I think it was an addendum. Wasn't it an attachment to the agreement?
Definitely was an attachment for sure. I don't know.
It's got all the other details in this.
Yeah, no, I think it had an attachment with the breakdown of the costs, which the first time they didn't give us, and the second time we got it. Yeah.
It's not attached here, though, right?
Yeah, it's not on there.
Well, how do we know that wasn't changed?
No, we don't. I guess. What was the other one you had a question on? 189?
189. That one. Maybe it was there and I didn't see it because I read it off of my iPhone, but I didn't see any of the redlining. So the question I had was, how was this rather lengthy purchasing manual differ from the pre-existing one? I didn't see where the edits were, and so I don't know what was changed.
I think Leslie prepared it, but it's totally new.
It was our QPA and Leslie that put that agreement together, and that was at the behest of Chief Valentine, who's putting together our FEMA money reimbursements, and part of that is to have a up-to-date purchasing manual. So our QPA, qualified purchasing agent, did add, deleted some things and added some things, but was not redlined the way the document from.
Well, that's the point. I don't have the pre-existing manual, and I don't know what was added, what was deleted. or the rationale for all those changes.
We don't have a whole lot of discretion in the purchasing area. Everything we do has to be done in accordance with the local public contracts law. So really all this does is parrot the local public contracts law. There are really no policy decisions in there.
Well, what was the pre-existing one? I mean, we had a purchasing agreement before, did we not?
Yes, it was about 20 some odd years old.
Yeah.
Okay, because none of that background was there.
Yeah, the purchasing laws have changed quite a bit since then, actually.
It was very short, as I recall, too, and needed updating. We've talked about it for a long time.
Yes.
I just wanted to mention that Tina told me today that the bid threshold could be increased to $44,000 from $40,000. So this purchasing manual has $44,000 as the bid threshold, but we'll put in the text of the resolution $44,000 just so that it shows up on the resolution. But that is one change I know about that Tina told me about today.
Yes.
Yeah.
Yeah. So we should just add a paragraph to the resolution saying, be it further resolved that the bid threshold is increased to $44,000 in accordance with state law, which would also increase the quote threshold to 15% of that.
Yeah. Okay. And that's what the chief needs that updated in order to apply for the FEMA grant. So. Okay, any other ones that we have questions on in this?
Yes, 190 for me. I don't know, it's the last one, so I don't know if anybody has anything before that.
That's the contract with Joe DeMarco.
Yes. I believe so anyway.
Yeah, it is.
Question?
Okay, so I'm just wondering that, because there's no kind of context around this. I know last year the bids came in, I think about a year ago now. I remember it was over the summer last year at some point where we had bids from all of the developers. And now we are, I think we've approved at least an initial $5,000 for this year for the redevelopment lawyer. And now this is going to be another $5,000 for the redevelopment lawyer. And what I'm a little concerned about is that I haven't seen any plans. I haven't seen what has happened to date. I mean, of course, I'm new to council, but and I was listening to their updates from last year, but we really haven't seen many updates this year. And on top of that, then I don't know what's happening in the future, right? What is going to happen? And this seems more like a time and materials request for dollars rather than, having a plan, knowing what our deliverables are, and getting something that is actionable rather than just continuing to spend money and we don't really know where it's going. So I know I'm not on the committee, so maybe there's some transparency that the committee members have that I don't. But if I know that if somebody's coming to me from a normal business perspective and they're just asking for money over and over again without having a full complete plan, I wouldn't approve it. So I'm kind of using the same thought process here, just understanding if we have a plan, if there's something that's going on since last year with the bids coming in and all of that.
So yes, we started to plan the finance committee. We outlined it for the 2020 budget, spending for both for the legal line item as well as all the other line items related to downtown development. The entire budget was included and is in the 2020 budget, which is item 20-191 on today's agenda. This amount is within the original estimate. In fact, at our current use rate, we're below half of the 2020 amount budgeted right now based on this amount. So we had 5,000 at the beginning of the year. This is another 5,000. The entire line was budgeted at 25,000. This was based on estimates that were provided to us by the Downtown Development Committee that was in place in 2019. The work that we're paying for this year is work that Downtown Development Committee, the re-envisioned Downtown Development Committee led by Mayor Canos, attended by myself and John Donahue. We've had multiple meetings. One of the outcomes is the Audi redevelopment plan that you saw tonight, as well as progress on Quimby Lane. I think the Quimby Lane information, we asked for an update to be provided, Mayor, to the council members, I think. And that was offered by Chris earlier this month, I think.
Yeah.
so that you could see the progress that we've been making as it relates to the Quimby Lane development work. We've met with the Downtown Development Committee itself, which Joe DeMarco attends, and we've also met with some potential developers and existing property owners as well. So the work is within the scope of the work that we originally envisioned, and I think it's productive work as well.
Thank you, Councilman O'Day. And also, I had spoken to Joe DeMarco about his costs, and he expects that, when we first hired him, we had no idea, what would be involved with a redevelopment attorney. So we just said, let's start with 5,000. He expects 10,000 should probably be enough. And then what he also said is at some point we can back charge, once we name a developer, you can back charge some of these costs to the developer. So even though we're putting money up front, a lot of it can be back charged, so it won't be coming out of our pocket.
Okay, and what's our timelines and plans for moving forward? And yes, Councilman, I did attend the meeting with Chris from Topology, but I don't see many updates at council for the public themselves to understand kind of what we're doing and how we're moving forward. So I don't have dates or timelines or anything personally either. They weren't discussed during the Topology discussion. It was just about the zoning and the uses and things like that.
We actually, the land use committee reports at each meeting, but we will probably have the Quimby plan for your review. I believe this is July, in August, hopefully with the goal of introducing it in September. So I think that's the timeline we're working on for Quimby, to have the plan in place. At that point, we're not sure if we will go back out for another RFP or re-interview some of the developers who already put in an RFP once we have the plan in place.
So in August, would the plan include timelines and deliverables and things like that? Like what's actually—
That really gets done through the development agreement, because then once— Please mute yourself. If you're on the call, please put yourself on mute. We're getting interference. Thank you. Where was I? The redevelopment plan has to be in place before we can name a redeveloper, I believe. Yes, Jack? Is that right? He said yes, I think. I saw his lips move. I'm sorry.
You're muted, Jack.
Muted.
There we are. Sorry. Yes, that's correct.
The plan has to be in place. I'm sorry. I missed. What was your question, Gina? Then I was
just wondering about timelines and the rest of like the process for actually like moving forward and making this happen. I know it's been going on for quite some time, but.
Yeah, it's very involved. Oh, the agreement, what happens is once we name a developer and we have the plan, what the redevelopment attorney does is negotiate the redevelopment agreement with that developer. And that's when you really work out all the deliverables, the timeline, what's expected, when the start date, what the end date, what the penalties, all the.
Yeah, I'm not even talking about the execution of the project. I'm just talking about a plan for the plan.
The plan for the plan is that you're gonna see a Quimby Lane redevelopment plan like we approved tonight. The one that you saw tonight was for the Audi site. Something similar to that, but for the Quimby Lane, which is a larger, more involved area, is going to be what's introduced in August and potentially on the agenda for September. Is that correct, Mayor?
Yes, I believe we have tomorrow night we have the redevelopment committee meeting. It's Chris's goal that tomorrow night we'll kind of finish with all the comments from the committee and then give it to the council for your comments, so that come the August meeting or the September meeting, we'll have it all ready to be introduced. So after the committee is done with it, then you will see it and we'll get your feedback as well.
Okay, so then tomorrow the discussion around, what you were saying of whether we go out to RFP or not, that discussion will happen as well, and the determination?
Probably not tomorrow, no. I think we have to finish the plan first.
And the RFP decision will be a full council discussion. Is that correct, Mayor?
Yes.
Yeah.
Yeah, we have to authorize that. So I think the first thing is to finish the plan.
Exactly.
Because that sets the parameters for where you go from there.
Okay.
Yeah, it's a lot. There's a lot that goes into it.
Yeah, I mean, I'm just looking because I'd asked, and Leslie, thank you very much for pulling the numbers together so quickly. Because I was asking about the past spend, and it looks like we've been spending about like $1,000 a month on the council fees, and I don't know how another, I mean, if it's only going to get higher or more intense from a negotiation perspective through the end of the year, I don't know how we'll only spend 10, but I mean, Councilman O'Day, you said we had 25 on this.
So in the 2020 budget, we have a line item of 25,000 for legal expenses, which we used as an estimate that was provided to us by the Downtown Development Committee. We tried to make sure that we have enough on each of these lines so that we weren't coming back to the council asking for additional money. That was the request from about 18 months ago, which was proffered by some of the other council members. It was before your time on the council, Councilwoman McCready. But the request was, please put in enough money to cover us, start to finish in this process so that we're not coming back for reauthorizations. So that's why the line is 25,000. Hopefully we won't spend all that money. And I don't think we're on pace to spend all that money. But we're not asking for incremental money at this point. This is money that we've been basically thinking about and planning for since about October, November of last year.
Right. Okay. I mean, and just in full transparency, it looks like we've spent since 2018, January of 2018, we've spent about almost $150,000 through to now, I think, through June at least of 2020, the numbers that I have. And what's the remaining budget for 2020 on this?
2020 budget was 131,000. The 142 includes some of that money though. So roughly you could estimate it at something around 250,000 for the total project, some of which may get billable back to the eventual developer, as the mayor already mentioned. But I also just like to point out that I think that this is a pretty substantial project. And from my perspective, it's the most important number one issue among constituents. So when I go to talk to the general public, the first thing that anybody will say is do something about our downtown. So while it's not free, I think it's a money well invested if we can move this project forward as we have already with the Audi site. And I think that, we're on track to do good work. We've got excellent partners in the business, both our legal and our downtown development topology group. And I think we're making good progress. And I think that it's going to be a plus that's going to pay dividends back to our members of the business community, as well as the residents of Bernardsville.
Yeah, I'm not disagreeing that the residents want something to do with the downtown. What that something is, they're very torn about. That's for sure. So I'm sure we'll hear lots of public comment on the plan.
And for what it's worth, I mean, I think Joe, for me, brings a good depth of experience because, first time a lot of us have ever been through something like this. He's done it many times before and kind of keeps us, working in the realm of impossibility versus getting lost in, we would love to do it. Ideally, we got to blend that with what we can actually do. And he threads that very well, I think. So to me, it's money well spent.
Yeah. So with his experience, then I'll stick with this additional 5,000 and hope that we don't get another change request coming in, especially without a plan moving forward. Okay.
Just to clarify, this is not a change request. This is money that was budgeted for, planned for, and this is part of our original understanding of an expense we were going to incur in order to execute this project. So it's not a change request. It's not an incremental expense. This is money that was planned, budgeted. It was in the budget all along. It's not incremental in any way.
Well, I think what's confusing is instead of when we hired him, we didn't just say, okay, here's 25,000. We'll write the purchase order for 25,000. We try not to overcommit, even though we budgeted that much. We say, well, here's the first 5. Let's see how far we get. So that's how we're coming back and saying, okay, we got to this point. So now we'll go back into that budget and take the next piece. But we didn't want to just say, write a purchase order for 25,000 because that's what we had budgeted. Does that make sense?
Yeah.
So let me just ask a question because I'm somewhat sympathetic to Councilwoman McCready's point. Let me ask it a different way. Given the I think it was $137,000 that we spent, are we at where we thought we'd be given that expense?
Absolutely. I think we are.
Yeah. And I share the sentiment too. And I think, Jeff, thank you for the explanation. I think we all want to see this move as quickly as possible.
Yeah, and I think, and Councilman O'Day's point, I think the public had high expectations on some of the downtown revitalization committee's presentations, and we were going to bring in University of Pennsylvania grad students. We were going to have all these plans. I think people thought things had moved along farther than we have been. I realize that we may not have managed expectations well, but I want to make sure at least that we're getting what we expected to get out of the money that's already been spent.
Yeah, and I think, Topology and Joe DeMarco, working with the two of them, they really are doing a good job of blending those expectations with reality. As John pointed out, I think they've done a really good job with that and working with all the different ideas and opinions. And I think the final plan, I think you'll all be really pleased with. But hopefully you'll get it next month. Okay?
So in just a small related matter. So I was talking to John Zabo. The zoning overlay should be ready soon. Do you want me to hold on to that until you guys present your piece in August, or do you want to start with that now?
No, actually, the zoning overlay would really help. Because we want to incorporate that into the plan.
Yeah.
Rather than having to keep saying, well, this is based on whatever, the zoning is going to end up being. It would be better if we had that while we're doing the plan.
I'll talk to John. He was attempting to get it to me for the 6th. However, he needs a little bit more time. So let me get a more updated timeline from him.
Yeah, but Councilman McQueen, I wouldn't think that we should not artificially delay it any longer than the quality product would require us to delay it. That's fine.
So, I guess the last thing I'll say about this, and if maybe tomorrow, if you guys can talk about it as a committee, then I would like to see some transparency to the public on, the plan for the plan. So not what the topology plan actually is, but what the process is, similar to what you were referring to, Councilman O'Day, with the NJDEP application process for the quarry area. I'd like to see the same for here so that people know, when the meetings are occurring, what's being discussed, what's our plan and timelines for moving forward, so that if it's a 10-year thing, those expectations are set. If it's a 5-year thing, those expectations are set. And I realize we don't have that type of information now, but we should have a plan to know when those timelines will come up.
I think that's quite reasonable, and I think that's something that we should definitely do. So maybe, Mayor, we can have that on our agenda for tomorrow night's discussion to come back either at or before the August 10th meeting with at least the near-term dates and deliverables that we can provide from the Land Use Development Committee.
Yeah, and I think that was something Chris wanted on the agenda, was to start setting timelines. So.
All right. So I think that's an excellent suggestion. Let's make sure we deliver on that. Yeah.
Good. Thank you.
Okay. Would someone like to move resolutions 2180 through 2190?
Well, just to be clear, though, we kind of went out for the 185. Do we know that there was no change to the appendix on the court agreement, the 185? Anybody looked at that?
The memo that we got from the clerk in Bedminster only said that the only changes were from the judge. Yes, in the language. Ralph, is that correct?
You're
You're muted.
You're muted.
You're muted, Ralph.
The thing. Okay, sorry about that. That is my understanding, Mayor.
Yeah, I thought I saw that. What I forgot her name. What's the clerk?
Judy.
Judy Sullivan.
Yeah, we had a memo from her saying that the changes were language from the new standing judge. So.
Right.
Joe DeMarco
Just to add,
What?
Joe DeMarco has his hand raised in the.
I was, just listening in on your conversation about me. So didn't know if anyone had any specific questions. And rest assured, unlike other things, this project's dear to my heart. If you ever need to cut my bill, because you need to, I will gladly cut it myself to get this damn project done.
Let's do it. Thanks.
All right. So just so we're all
be careful what you offer,
No, that's
careful
okay,
there, Joe.
Mayor. I would volunteer my time for this if my partners would let me. But I mean, if it's a matter of a couple $1,000s to get it done, let's get it done.
Thank you.
Okay. Thanks, Joe.
Not a problem. Have a good night.
You too. Okay. So are we good?
I was going to ask Jeff about the hours because in looking at the Bedminster Court, that document that they gave us in our agenda package, it's on page 90 that it talks about the hours, and it basically says that it's going to be set by the court staff and judge. So I think, maybe now it's still only Tuesdays, but that might change, and the document, the way it's written, allows them to do that.
Well,
I agree
that
with
changes things. If they can unilaterally change it, then I would not be in agreement with this. I'd like to vote for this separately.
Where is that, Christine? Page 90, you said? In the packet?
One second. I'll give you the number and letter. My computer's just a little slow.
Because really, nothing in the language, you can see the red line, what's different. It says, what the staff, she added the staff, that they would be specifically named. And that.
Wait.
I don't see anything about the money under the days or.
Yeah, they do a good job of burying it, but I just saw it and it said,
Yeah, and I didn't see it. It was really spelled out in the last document, easy to read, kind of a tabular format.
Yeah, they did add a table last time. It's not on there this time. But I agree with the mayor. The representation was the only changes were those red line changes.
Well, that's what they may have. I don't know who's something, but we got to go by what's written and what's presented to us.
I agree.
It's letter I on page 90.
Oh, thanks, Anthony.
Which is it?
Letter I.
What letter I on page 90 of the agenda packet?
Oh, I'm talking about the actual part where it talks about the hours.
Oh.
This one, it was page
I'm in agreement with Jeff. I think we send this back to them and tell them to put the hours in there as they currently stand.
Days and hours.
Yep, that makes sense.
Yeah, so we have a minimum representation of what we're getting here.
When you say though, Councilman McQueen, as it currently stands, aren't they changing the hours?
Well, so if they're whatever they're changing them to.
Okay, got it.
Whatever it is as of right now, I think I want that in writing and a minimum representation of what our time is.
Well, what I'd like to have in writing is what we agreed to. If we agreed to a day and a half, that we expanded it from Tuesday to a Tuesday and a half of a Thursday or whatever it was, then that's what should be written down.
Mm-hmm.
Yeah, we don't have, there's supposed to be the attachment of that, and they didn't include it. So.
Yeah. And Berners Township certainly delayed this a number of times. So.
Yeah, let's pull off 185 and just move the rest. So would somebody like to move 2180 through 190 without 185? Yes?
I'll move.
Okay, do I have a second?
I'll second.
Okay, roll call.
Mr. Donahue?
Yes.
Mr. Hammond?
Yes.
Ms. McCready? She's muted.
Where'd you go?
She's muted.
Oh, did you? Yeah.
I'll go on and come back. Mr. McQueen?
Yes.
Mr. O'Day?
Yes.
Ms. Zamara,
Yes.
Ms. McCready.
Yes. Sorry.
So we're not going to vote on 185. We're going to send it back.
Yes.
Pull it. Okay. And ask for the attachment or whatever other data we need to assure us that we get the right amount of hours.
Yep.
Oh, it was page 89, letter I. And it says, shared municipal court sessions and the hours of the court administrator shall be established in consultation with the municipal court judge, municipal court administrator, assignment judge, and vicinage municipal division.
So
Is that what you're looking for?
But does that mean then we agree to it and then they set the hours?
Well, that's Article 1, scope of services.
I see it.
Lettered A.
But it's kind of saying that we're going to, we sign this
To L.
first and then they set the hours, which
Yeah.
Right.
kind of backwards.
Which we don't want to do.
No.
Yeah, which we don't want to do. Agreed.
Yeah. Okay, so we'll pull it off and tell them we want more details. Okay, now we are up to 2191, adopting the 2020 municipal budget. So I will open the public hearing on resolution 2191. Does anyone from the public wish to be heard on the budget? I don't see any hands going up. Anybody? And just for Tom, I don't know if you want to make any comments. I know we worked on this for 9 months? This was a tough one with all the changes and the revenue and the state and the delays.
Yeah. So I think we have talked amongst the council members as well as in the introduction back in June. I think we've gone through all of the details. Nothing has changed in the last 30 days since we published it. So I don't think there's any new information to provide, but obviously if people have questions, we can try and address those.
Anybody?
Yeah, I don't have any questions. I only have one request, and I guess officially go on record as that as a council, we convene shortly within Q3 this year to create an earlier plan going into next year that includes long-term debt. And I know, Jeff, Councilman, this is something that's been important to you, and I think it's important discussion that we make sure we have before we get into the next budget cycle next year.
Yeah, so I would propose perhaps that we schedule a meeting between now and our next council meeting among the finance committee to address specifically debt service plan, the multi-year debt service plan that's in place, and maybe even consider having that on the August 10th agenda.
Okay, and Councilman McQueen, you had talked about in the past, and I'm not sure how this gets codified, but or if it, I don't know how this works, but it was mentioned about setting expectations with the heads of all of the departments for next year's budget for 2021. And
yeah, I think that's all part of it, and things that have been discussed, such as having more line itemization as they're going through the budget process. I think let's just have a global discussion about all these points. We can do it in an open session. We can do it August 10th if the agenda. If the agenda permits. I just don't want to wait until next December to start having the discussion.
Well, and I think one of the things we did invest in a new budget software that Leslie has been working on, which I think is going to make it an easier, clearer process to see more of the line items. So maybe at some point when Leslie's comfortable with it, she can maybe do a little session with us on it if you're okay with that. She's nodding her head. Yes. Okay. Because I think that's, part of the reason we invested in it was it was a much more oh, hey there. Hi. Was a much more transparent system that allowed for more detail that you could see and review. So I think that'll be a big help in that process. And we will get into that. Finance Committee, we will be meeting. So thank you. Anybody else want to speak on the budget? If not, I will close the public hearing. Tom, you want to move that?
Yes. I'll I move that we adopt the 2020 municipal budget, resolution number 20-191.
I'll second.
Roll call.
Mrs. Zamara?
Yes.
Mr. O'Day?
Yes.
Mr. McQueen?
Yes.
Ms. McCready?
Yes.
Mr. Hammond?
Yes, and I'd like to thank Councilman O'Day and Donahue and the mayor for all their hard work on this.
Same.
Agreed.
Mr. Donahue?
Yes.
Okay, we have a budget. Council Public Safety Committee, Jeff.
Yeah, thank you. We met and took up the item that we had discussed at the last meeting, which was the anti-bias, anti-discrimination resolution that the freeholders had passed and asked us to consider. And we had decided that we would like to craft our own language. We've met and discussed that. We're in the process. I'll hopefully have some language for the council to consider at the August meeting, the next meeting, the August meeting. I have reached out to the New Jersey League of Municipalities, and they don't have a template or any such language, nor do they have any educational materials or training materials. I'm in discussions with the New Jersey Division of Civil Rights to see what they have. So we'll put together a package and have something for August. Other items is that we've had reduced staffing within the police department. We have one open position that was the Chief Valentine had agreed to leave open as part of our budget reconciliation and process. Then we have other officers either out on sick leave or have been detailed to other responsibilities at the county level, for example. So we will have to have a change in some strategy over the next 6 months of how our officers are deployed. We then also have, coincident with this, modifications of our procedures due to COVID. And so there is still reduced access to the headquarters lobby, for example, and then everybody working in headquarters is wearing a mask and social distancing and things of that nature. So that has placed an additional burden on the department. The police officers will be present at the Bernards High School graduation to help with crowd flow at the two ceremonies that are going to be conducted for the graduation.
What's the date on that, Jeff? Just
Sorry?
The date of the graduation?
If you give me a second, I'll pull that up. I thought it was the 17th, but I could be wrong.
Yeah,
it's tomorrow.
It's tomorrow?
Tomorrow? Oops.
Oh, maybe.
I believe all the chairs are set up there.
Oh, yeah, I think you're right. Yes, because they're doing project graduation. Yeah.
Okay, so it's not the 17th, it's the 14th. Okay.
Okay.
And then, and I think that's it. That's my report, unless the chief has anything he wanted to interject.
No, that's it. Thank you, Councilman Hammond. The graduation is tomorrow, the 14th. I thought it was the 17th at first as well, but they're all set up and they're ready to go tomorrow. Tomorrow night, they have the project graduation at the high school field. It's their last get together for the senior class. And we will also have officers present at that event as well.
Oh, and I had one other item. It had to do with speeding mitigation. We did get a request that we pay some additional attention on Lloyd Road, and the chief has detailed some officers to provide increased surveillance and also put one of our electronic speed monitors there to kind of get some baseline data.
Okay, thank you, Jeff. And the good news is the weather's supposed to be good tomorrow.
Yeah, thank you for that, Jeff.
Yeah. Finance, Tom, I think you've done enough.
I don't have anything more to add right now.
Good. Thank you for all your efforts on the budget.
Thank you, everybody else as well.
Yeah. Personnel Committee, Chad? Do you have
Yeah, we didn't meet. We did not meet since the last meeting. We took a little bit of break after Bob was hired. I'll reach out. I think it's about time for us to have another meeting, so we should have one before the August meeting.
Okay. Christine, Public Works?
Public Works is a road department report. Is basically there's been a lot of the day-to-day repairs in our agenda package. So I just want to point that out to people because it looks like a lot of the small tasks are kind of hiding within these big tasks like mowing and cleaning catch basins, and they're also pitching in with the food bank, the food pantry, I should say, and the banners that we put up for the graduates. That look awesome. That's all done by our road guys. So they reopened the playgrounds, which is great. They put up the basketball hoops again, and they've been bringing and putting some wood chips on some of the trails that are now getting used a lot more than usual, which is great, including Laurelwood Trail. So for any of you who've never experienced Laurelwood Trail, it's one of the most beautiful vistas in town. I encourage you to go check it out. And now it's all cleaned up. If you do go and you notice something that needs attention, you can always reach out to the borough via email or call. And we always do our best to address. We're also going to work on signage for those areas and to try to just make it a little bit better or clearer as to where the trails begin and stuff. So in addition to that, we have our road work, which is always many projects. But the first item was this has come up in past meetings about the road moratorium. So when a road is paved, there's a period of time when we don't want the gas lines being installed or any of that. So there's a moratorium on the road, and all that information is now on the borough website. So if you're a potential home buyer on, Anderson Hill, you know that there's a moratorium and how long it lasts. So that process has been cleaned up. Milling and paving are in the works for Picklebrook, Old Army, Mullins to Anderson, and Meeker. Hull, Lindenberry, and Lloyd are to follow. There are some grants that we've submitted for Chestnut and Crestview, so we're hoping to get good news on those. We discussed the walking path at Polo Grounds, and it's more of like a connectivity to what exists there already, and the Recreation Committee is looking or providing us feedback on that. Hull and Lindenberry is in the works. Lloyd Road is also in the works. White Neck Road, and all of these projects, any residents in these areas are being notified. So if any residents have concerns or, want communication with us, they can always call the borough or email the Public Works Department. We're still hopeful that the mural project's going to be happening in 2021. So we're just in a hold pattern on that. The library final inspections are this week for the roof and the HVAC. There's also some mold remediation work happening there. So that might be completed, I think, by this week. I don't think Doug or John is on this call, but and Jeff, you already mentioned the police station mold remediation. That's also in the works. I think that's it, unless Gina or Tom, did I miss anything?
No, you didn't that I know of.
No, I didn't know if you wanted to talk more about the path at the Polo, though, with, getting some feedback. I know we've gotten some emails based on some of the posts that you put on the bubble with the, riding the bike over there and things like that.
Yeah, I got a few emails from residents who obviously would love for something to be existing there that's paved. And we talked about accessibility, and we talked about the definition of what constitutes an ADA accessible trail. And basically, it's a firm and flat surface. So we all realize that a firm and flat surface could be a black tar paved surface, but we're hoping that we can come up with an option that meets our financial guidelines, because we don't have an unlimited an unlimited number to work with, unfortunately, for a recreational path. We want to get as much possible resident use out of it. So that's why we are seeking resident feedback. We're going to hopefully find some kind of middle ground as far as having something that can be used in the near term, because it seems like open spaces are really what's going to benefit our society most at this point, and our residents' health. So we just want people to get outdoors and be able to walk safely on a firm and flat surface. And we know we are blessed to have some of those, and we're hoping to be able to, you know, just enhance that a little bit if we can within our budgetary guidelines.
One of the other things, I think Doug sent around an email, I believe it went to all council members, that they had used, lining to outline where the path would be created, and invited council members to walk that path. I did myself, and location wise, I think it makes sense where it's laid out. It connects to a pre-existing pathway at where it ends. So at one end, it's near an ADA accessible ramp, without a curb, so that a wheelchair could get up over it, or a bicycle. And then at the other end, it terminates at another pre-existing walkway. So I do think that we could go ahead with it from a location standpoint. I think it's acceptable.
Yeah, I forgot to mention
the duty calls, the dog bags. So any of you dog lovers out there, you can go take your doggy for a walk, and you can forget the poop bags. We have them provided for you, so we can make sure you pick it up. So that was in our payment of bills.
Yeah, I remember. So I remember at the last meeting, I believe Councilman O'Day was talking about a QP crushed stone path that he encountered, and I actually happened to encounter one over in, where was not Chestham, Summit. Really nice, and there were little kids riding the crushed path the entire time on bikes. I was initially, I guess, questioned whether or not it would work, but I think this was something similar to what he'd mentioned, and it seemed to work really well. So,
yeah, and that's what we talked about with Doug when we were, I think, Councilwoman McCready, Councilman Zamara, and myself met Doug out in the area. We looked at photographs, the ones that I had sent on to all the council members from East Park over in Warren, New Jersey. And it sounds like it's very similar to what you perhaps saw in Summit, Councilman McQueen. And I do believe that a pathway like that would be fit the definition of a flat, firm surface. And I think it's actually a good, cost-effective solution. It does not prevent us from doing something more substantial in the future either. So I do think it's a good approach right now.
Well, and I want to be careful. There may be the feeling or the gut reaction, think, oh, you're not paving it, they're doing it less well. But it's probably a more forgiving surface as well. So there may be positives to it.
I do think so. I think it's not just it's not just a cheap solution. It actually is somewhat of an elegant solution, at least in the experience that I had over at East Park and Warren. When done properly, it actually gives a fairly nice walking or I would think riding surface as well.
Yeah, you said that better than I did, so thank you.
Yeah.
It's also the environmentally friendly way to go, because it's permeable as far as rainwater and drainage goes.
Yeah, what one resident I think mentioned was that the cross country runs through there, or at least there's a trail of sorts that cross country runs. So it might be something worth talking maybe to Mr. Hoppy about, or the cross country coach or one of the kids, to find out what the trail actually looks like, and walk it and make sure that we're not really interfering with the two.
Yeah, that's a great point, Councilwoman. As somebody that ran as a kid cross country all the time, it's more difficult to run on pavement. If you're a cross country runner, you could take your cross country cleats onto a crushed surface like that you wouldn't be able to take onto pavement. So it may even be a better solution for that particular location.
Great. Whatever happened with the bid? Because we initially had said we were going to go put this out to bid because it wasn't going to cost us any additional money. And then we found out it was going to cost us additional money. Where did that ever land? Do we know?
I think we were waiting for the rec department's feedback before we went out to bid, but that the cost of going out to bid was already included in that ordinance. But I can double check that with Doug before our next public works meeting.
Yeah, because we have a rec committee meeting tomorrow night. So if I want to make sure it's on the agenda, or if there's new business, I can bring it up in new business if it's not on the agenda already.
Okay, that's it. Thank you, Christine. That was very thorough. And also Laurelwood Park is now being done as an Eagle project. So it's really getting spruced up nicely. So if you haven't been on that, it's a little straight uphill at first, but it's only, I think, a half a mile up and a half a mile down. So it's a really nice path. And I think Ed English was taking the group in to start working at Peter's Track to clear a path up there. I don't know if that actually happened. Do we know if that?
That was the Warren Blue Ridge group.
Yes.
They are doing that this week, I believe. Right, Anthony?
Yeah, he's slated to do that on Thursday, but I'm waiting for insurance and a hold harmless agreement. But I believe he's looking to do it on this Thursday, the 15th, or the 16th. I think 5 o'clock. I want to say.
But is that a real walking path, or is that just an access for the hunters that are part of that group to get to their stands?
There is a path marked. I think it's just so overgrown you can't get on it.
Oh, that's for sure.
Yeah, it will serve as both.
Yeah. It's all the, the pricker bushes there that are, they have the equipment. You can't get those out by hand, I think, without a machete. Next committee, Land Use Committee. Actually, I think we covered that, and we'll be meeting tomorrow with that group. So let's see, any other, we don't have housing. Jeff, anyone have questions for Jeff Price on his report? We did have a housing committee meeting. Chad, I don't know if you want to report on that or.
Sorry, I was on mute. You probably didn't hear me. Yes, we had a housing committee meeting. The good news, so about a year ago, we started to focus on a bunch of areas in our town where we had a large list of violations. The biggest takeaway out of that meeting is most of those issues have been completely resolved, and the places that are being replacing the ones that we identified as problems are far less severe, and they're getting resolved much quicker. So the things that we moved this evening, the work that Jeff and Renee have been doing, it seems to be working. So thank you for that, and I'm pleased to report that things are going in a positive direction.
Absolutely. Jeff, did you want to comment?
No, I have nothing to add to what Chad just said. We're very happy that you introduced the property maintenance ordinance, and as I said before, that's going to make things a little easier for us. Thank you.
Okay, thank you for all your hard work. Anybody have committee reports, liaison reports?
I have rec.
I have library.
Okay.
So yeah, the Board of Health hasn't met. We'll meet again next week, I believe, is our next meeting. And but I really wanted to just really say a big thank you to the rec department, Neil, and our new rec director Bob, who started in June 17th, I think it was. Really feet in the fire for him for sure, because he came in amidst the pool trying to open and trying to understand rec camps and really reorganizing and getting everything under the COVID situation. We are the only borough who opened rec camps this year that the Board of Health has oversight for, and they reviewed all of the plans and approved all of them. The kids started today. My two younger ones are in there. It went fairly smooth considering it was day one. They're all getting their temperature checked inside the car before they get out, and they're keeping with groups of 10 and maintaining that. So hopefully everything will continue to go smoothly there. They were almost at their max. They had a limit of 50 kids to register, and they were at 49 as of yesterday. So I don't know if anybody had joined late today, but they're completely maxed out. So from a budget perspective, the council members who were concerned about that, Rec Camp has got it covered. Thank you to the Bernardsville Borough and the non-residents who are attending. The pool is in a similar situation. They brought in the budget that was necessary at a minimum to break even. So, and I haven't checked after that to see exactly where we are, but things are going well. Of course, they had some hiccups with opening. They opened up a couple of days after their original target because of electrical issues with the inspection, but they got everything scheduled and up and running, and they were open for a day and then closed with the storm. And then we had a tree fall over in the storm and knock out some equipment as well. So it closed them then for Saturday and Sunday as well, but they were open back up again today. Fairly good membership attendance today. I know I picked up my son there about 4 o'clock, and a lot of people were still even just starting to come in. So things seem to be going really well. So good work for Ralph, for the team, for Bob and Neil. I'm sure they're not on because they just closed the pool at 8 o'clock and they probably just went to bed or at least eating dinner. So thank you very much for all the hard work for you guys. And hopefully for the budget, we are in good shape too. So thank you guys.
I'd like to just echo what Councilwoman McCready said. Thank you for all the staff, especially the rec staff who worked on this project. I know it was short notice, and they really went above and beyond to deliver this for our residents. I hope that everybody stays safe and enjoys their summer.
Yeah, absolutely. And Jack, I just had one other question for you because Jack was very persistent in trying to gain access to the Board of Ed lawyer, and he was able to get in contact with her, and they were able to reach an agreement. And Jack was writing that up. So Jack, where are we on that agreement?
Yeah, I've written the agreement, as you know. I was waiting to hear back from Bob. I wasn't sure what his position was on it.
Okay. Okay, great. I will follow up with Bob and make sure that he responds. So at a minimum, I think that, I think he was in agreement that, we needed it for inclement weather and the outside bathrooms as well. So let me follow up with him and I'll have him respond to you so you have an official.
Great. As soon as I get that, okay, I'll forward it to the attorney for the board.
Yeah. Okay, great. Yeah, because one of my daughter mentioned that, they were maybe going to get access to the school for the bathrooms today. So somebody must have said something.
Yeah, the agreement's all done, as you know. We just have to plug in the areas.
Okay, perfect. I'll follow up with Bob and just make sure he gives you a definitive response on that.
Okay, thanks.
Just a quick question. There were a number of municipalities in the vicinity who did not open their pools. Morris Plains comes to mind, as well as I know there were others. Did we try to market to them to see whether any more out-of-town residents might want to get a membership at ours?
Not that I'm aware of, and I highly doubt it with all of the scrambling that they've been doing, but I will bring it up tomorrow at the rec committee meeting and see if there's plans for that.
Great, thank you.
Okay, Jeff, you had library?
Oh, yeah, thank you. First of all, I wanted to announce that Madeline English had rendered her retirement. I won't say resignation. She's going to retire, and she deserves a shout out. She's done a huge amount of good work for the library and program development, and that'll be a loss for us. We also had 3 employees that have elected not to return to work for a variety of personal reasons, and so we're going to have a reduced staff, and that's going to impact our reopening plan. And we have had a phased and gradual reopening that'll still continue. The plan we have in place now is through August. There'll be some limited hours, but we're transitioning from curbside to sort of a grab and go, a pickup of books or material from the library. So the reopening is continuing. It'll be a little bit slower than we anticipated because we have less staff, but it's ongoing.
Hey, thank you.
Can I also, I wanted to talk about the green team, even though we haven't met. The farmers market has been going strong and so well organized throughout this past couple of months that I really want to commend those volunteers, especially Ed English, for all the hard work that he's been doing. Madeline's been standing out there early on a Saturday morning, directing people how to proceed through the farmers market safely and keep everyone safely distanced. So I just want to acknowledge that hard work, and also any residents who may be listening and want to wake up early or maybe even not so early on a Saturday and help out. They are still looking for volunteers, and you can always email me or anyone and we can put you in touch with them. In addition, I met with the Environmental Commission, and they've been making a big push, among other efforts, to educate and help people stay informed about environmental efforts that they can do while stuck at home and bored. And one of those things is the new Environmental Commission Facebook page. So if you haven't seen it, take a look. There's a lot of good articles and information that you and your family would probably benefit from. So those are my two council liaison reports, Green Team and Environmental.
Thank you, Christine. Yeah, and if you haven't seen the Facebook page for the farmers market, check that out because Ed does the best videos. It's almost every week he does a new one, and he features some song from the band that just meshes with it. I mean, he's just so great.
Oh, the band, they're so
Yeah.
good.
JC, what is it? PB&J.
PB&J.
Yeah. So, and it's great that those guys have volunteered to do that. Okay. Anybody else? Did I miss anybody with reports? All right. So now we are into items of business, and we have the appeal from the DePodwins for the Shade Tree Committee permit for 31 Old Colony. So, Jack, you want to tell me what we do?
Yes, the ordinance requires that the parties be given the opportunity to be heard. So we don't need a full-blown trial with cross-examination and court reporters and all that. So I did send a suggested set of ground rules to the mayor for your consideration. One would be proof of service of the notice, and that is in the packet. So that's been satisfied. Neighbors within 200 feet have been notified. Then to identify items in the record, and I think you all have copies of those. It's a copy of the permit with a copy of the application attached. It's a copy of the DePodwin's appeal to the council. Mr. DePodwin also submitted 3 photographs and any additional items that anyone may want to place in the record. I suggest then that the parties be given 3 minutes each to make a statement. First, the applicant, Maria Jennings, then Mr. or Ms. DePodwin, and then any other interested parties, if it's from the Environmental Commission or whatever, or just residents who would like to make. Then open it to questions from the mayor and council, then deliberate, and then either issue a decision tonight or announce when you're going to make that decision. So those are my suggested ground rules for proceeding tonight.
Sounds good. Okay, so do we have a limit on the time for each person, or?
Yeah, I suggest 3 minutes per person. Obviously if they get questions that may go over that, but as I say, this is not a full-blown trial. It's giving everyone the opportunity to be heard.
Okay, and we did have, I think we had copies of the application. We have copies of Mr. DePodwin's submission. He also had photos that we received today.
Yes, three photographs he submitted.
There were 4.
Four? Oh,
yeah.
Okay.
Okay, so we will start with the applicant. Marla?
Is that me, Marla Jennings? Okay, yeah. Hi. My name is Marla Jennings. I am a new resident in Bernardsville. I moved in August of 2018. I have done significant improvements to my home. I have repaved my driveway, and I was very cognizant of the water problems that occurred on not only my property, but the properties on both sides of my home. And I've done a lot of, I spent a lot of money and did a lot of work to remediate a lot of water problems. After I renovated my driveway and repaved it, I put Belgian blocks in to make sure that the water from my driveway was not going onto Mr. DePodwin's property. I had sump pump issues. My sump pump was pumping the water from this home, bowing a landscaping wall and pushing the wall out, and it was all flowing downward onto the DePodwin's property. So I rectified that entire problem. Last year, Mr. DePodwin was very happy with what all the improvements I made. I took out a tree that was on the left of my driveway, and I really did not anticipate that tree removal coming up in even this potential tree removal. Clearly, I'm offending Mr. DePodwin when I am removing trees on my property. I feel like I have been being told what to do and how to manage my property. This tree is very large. It's not that I don't like trees. I do like trees. This tree is a beautiful tree. It's just in a very bad spot. It pollinates in 6 months out of the year. It's debris is falling off this tree in the spring and in the fall. It falls all over my driveway, all over my car, clogs my gutters, clogs my drain. And quite frankly, I prefer it to not be there. I sent in the application. I was approved. I innocently told Mr. DePodwin what my plans were out of a courtesy. And, I certainly didn't anticipate him to react the way he did. He sent me a letter telling me that I should park my car in my garage. I should stop targeting trees. I felt a little harassed, and I honestly would never have told him how to manage trees on his property. My question would be, if this tree falls and hits his house, would he come to me if I don't take this down? I mean, these are home ownership issues. I do not believe that I'm not relying on my neighbors to the other side of me to manage my water problems. I don't think it's my responsibility as the homeowner of 31 Old Colony Road to manage his water problems as well as his air conditioning desires. So that's basically what I wanted to say. I enjoy living here. I like my home. I love the area. I've been a Basking Ridge resident for the last, since 1990. So I've done a lot of stuff in Bernardsville, and that's why I chose to move to Bernardsville. And I'm just very surprised that I'm in this position because I thought I did everything the way I was supposed to do it. That's it.
Thank you. No, thank you for that. Does anybody have any questions? Can they ask her at this point? Yes, Jack?
Sure.
Or
I do have one other point I failed to mention is that Renee Puzo, who's our zoning enforcement officer, also serves as the tree conservation officer. She issued the permit and she is available tonight to answer any questions if you have any questions for her.
I have a question for Renee.
Hi, good evening.
Hi, Renee. So was an application for a tree permit removal submitted to you?
Yeah, it was submitted on, I'll give you, or at least I'll give you the exact date of when we received it. We dated it May 26th of 2020.
So is there a time frame that you normally respond to one of these requests?
The time frame is usually about a week. It's not set by ordinance, but I usually give it a week at the very most.
Did you visit the property?
I did visit the property.
Did you evaluate the request?
I did evaluate the request on the permit.
In your opinion, did it meet the criteria for being approved for removal?
It did by ordinance.
Is the homeowner supposed to do anything in terms of replacement trees or anything?
Yes, and that is what is on the permit approval, the obligation to replant and or to fulfill the Borough Tree Trust Fund. They have the option to do both or replanting all of the, which would be 7 in this case, 7 replacement trees.
Okay, so your evaluation then was sent back to the applicant, is that right?
That's correct.
Okay, thank you.
You're welcome.
So along those lines, what criteria was it that within the ordinance that it met that justified tree removal?
So by ordinance, there is nothing that I, from my recollection of going through the ordinance, the tree protection ordinance, that would allow me to decline Ms. Jennings' request to remove these trees, as we do have a tree replacement obligation. If you remove a healthy tree, so to speak, or if it's in good, condition, you do have to replace with the, which actually we just modified the replacement requirements back in October. It was in front of the council. So just to kind of give you a synopsis that, we have a chart within the ordinance that explains the tree replacement obligation. So in this particular case, Ms. Jennings, she was removing a pretty healthy maple tree. So in that instance, the category is by the DBH, which is the diameter breast height of the tree. And we have a tier within the ordinance that then dictates how many replacement trees are subject to that removing of that tree. So in this case, it falls in the category of 7 replacement trees that have to be a 3-inch caliper. And it is their obligation to plant them and or pay into the tree trust fund within 1 year of that permit. So in addition to that, the ordinance does kind of go on in terms of the option that someone would have. And what I mentioned was the Borough Tree Trust Fund. So if Ms. Jennings wanted to, she could, at 25%, according to the ordinance, she could plant 2, which would be 25% of 7, the whole number of how many she has to replant. 2 has to be planted on site within a year, and then 5 would have to be paid into the tree trust fund at $125, which is, the going value, market value of a tree, according to the Shade Tree Committee, that then gets paid into the tree trust fund. So there are many options to this particular obligation that Ms. Jennings could have, but that, just so that I fully explain it to you, it's not just a cut and dry, put 7 replacements on your property. There's kind of a series of options that she could do. She could plant, 5 and pay 2 into the tree trust fund, as long as she's meeting 25% at least be planted on site, and no more than 75% of 7 can be paid into the tree trust fund.
Right, but that's the remediation. But the question, and I'm following up on Councilman O'Day, he said, did he meet the qualification? Did he meet the guidelines or some language? I can't remember specifically for removal. So the question I had was, does the ordinance give any kind of guidelines for what trees can or cannot be removed, or does it basically, if you pay the penalty, you can remove any tree?
So the only instance that you can't remove a tree is if it's on the, I think, the state historical tree historical list, for lack of a better term right now. And I believe it would have to have been, it's a very small reason why, and that I know is one of them. But there's nothing against taking down a healthy tree on your lot. I know for sure, because we've had plenty of tree permits come into this office, and plenty of other people have taken down healthy trees, and reading through the ordinance, it makes sense that they absolutely can, because it makes sense. That's why we have a replacement schedule and paying to the tree trust fund. We have other means to make up for taking down, a healthy tree.
So the ordinance doesn't speak to any impact that it might have on the drainage or water table or any of those other factors.
It doesn't in this case. And I think where possibly people may differ in what I'm saying is when you're reading through the tree protection ordinance, it weighs heavy on site plan review, which is when it's in front of the planning board or the zoning board. There are much different requirements that are put on the applicant at that time, where this is a privately, in my case, I call it a simple permit application that does not involve the planning board or the zoning board. This is just a simple homeowner trying to take out a tree. It's a healthy tree. She's subject to the replacements that's within the ordinance, and that is how I did my review, as I would with a similar situation.
And the state sets the replacement cost for trees, the $125. That's set by the state.
It's set by its market value, is how it's worded in the ordinance.
But the borough set that number.
That's correct.
The shade tree would have at one point in time, and it remains.
That's the market value of a tree of the caliper that has to be replaced, 3 inches or whatever it is. Is that right?
That's what's been set by the shade tree committee before I came along. So that's what it's been, the $125.
If you look at the size of the tree that was in the photo, it's more than $900,000 to replace something like that. Okay, that's probably something to visit in the future.
So does it specify where you put the replacement trees, or is it just anywhere on your property?
There is no specific, just that it has to be on your property.
And the other thing
is there anything to the maintenance of the tree? Like, you plant the tree as a replacement, but you don't take care of it and it dies within 6 months. Is there anything in the ordinance that speaks to the maintenance of the tree?
The ordinance does not. There's no requirement pertaining to maintenance, which we've discussed this at shade tree meetings, but I think this is about the appeal in front of us to.
Oh, right. I'm just trying to understand the ordinance.
It's a very long ordinance when it comes to the many different, I think, variations that you could have. It's, every kind of situation is slightly unique. But in this case, I definitely reviewed the ordinance. I know that what my review is based on the ordinance, and that is how I approved it.
Ms. Apuzzo, I have another question for you.
Sure.
So if a tree were dead or diseased, would you be subject to the replacement of that tree?
According to the ordinance, you would not.
So effectively, the ordinance is really meant, or it's anticipation of people taking down healthy trees. The ordinance doesn't really apply to a dead tree or a diseased tree.
In the sense of replacement.
Right, in the sense of replacement.
Right, so it's heavier on the basis that if you're going to remove, and this is my interpretation, that if you're removing a healthy tree, you're subject to the obligations that are in the ordinance, which is replacement and/or paying into the tree trust fund.
Okay. Thank you.
You're welcome.
Any other questions?
This is Dave DePodro. Am I allowed to ask a question based on anything that's been said prior to giving a statement?
Yeah.
No, I think you'll be permitted to make your statement. This is the opportunity for the council members to ask questions.
Okay.
Ms. Apuzzo.
Okay, I'll make my statement when I'm allowed to make my statement, and then I'll ask my questions when I'm allowed to make a question. Thank you.
I did want to ask about the appeal process, right? So this is not the first appeal, right? It went through a Shade Tree Commission prior to this, correct?
Yes.
So is the commission here as well? The representative from there?
I believe.
See Ann Wazeter on here. Peter Birnbaum.
Yeah, Ann Wazeter signed the letter.
Yeah.
She's the chair.
Yes.
So, Anne, may I ask if your response to the appeal had a similar response to Renee's initial assessment? It was following the ordinance?
Councilwoman, you're asking that question of the Shade Tree Committee?
Yes.
I see Anne's name on the list. I don't know if she wants to speak to that.
She's not on mute.
There's on page 141 of the agenda packet is her written response to the appeal.
Yeah, I read it, but I'm just wondering if, you know, if
Okay, can people hear me now?
Yes.
Yes. All right.
Thank you. Okay. Ann Walsh-Rosetter here, Chair of the Shade Tree Committee. Glad to be with all of you. And to answer your question, Jenna, June STC meeting, I believe it was June 17th, we met at our regular meeting with an agenda and had the appeal of Mr. DePodwin's added to the agenda by Anthony, thank you, and it was one of the items we discussed. My recollection, without the notes in front of me, was that we listened to Mr. DePodwin's remarks and also to Ms. Jennings. And then I did a roundtable, and those of us on the committee that were in attendance all made remarks, asked questions, or made comments. There were 2 people missing on the committee, that's my recall. But many times we've had situations similar to this, not exactly, where not everyone was at the meeting. So we work with who we have at the meeting. After all was said and done, the go around the room and everyone make their remarks. The determination and final was the Shade Tree agreed with and supported the TCO's decision to grant a permit to Ms. Jennings.
Great, thank you very much.
Let me follow up on that. And was there a quorum? I mean, you made it sound like not everyone was there. Did you have a quorum?
I think I'd need Jack for this because we've gotten to the point where, given the membership, we did not need a quorum anymore. But I think we had a quorum, quite frankly.
Because
I think
the minutes you sent did not list who were the voting members and who voted yes and who voted no. It was silent on who was actually there.
I didn't realize I had released the minutes.
Not the minutes, the memo that you sent or the email that you sent.
That was,
okay, no, I did not have that.
Yeah, that was
the quorum is the majority of the membership.
And I think we had a majority, by the way.
Was Dennis there? Was the forester there?
Dennis was in the attendance. Renee was in attendance.
Okay, thank you.
If I could add, Councilman Hammond, just so you know, Dennis and I did go out to the site together after my initial visit, just so he did have a good synopsis from a forester's point of view. And we were on the same page according to the ordinance, just so you do know.
Could I make another statement? This is Ann Wanzetter.
Yes.
My recall from my notes, and I can get this confirmed for you all, was while everyone was in agreement and we supported Renee's decision as the TCO, there were 2 people in attendance at the meeting who did reflect what probably all of us feel, that I'm not going to say we mourn the loss of a tree, but we don't exactly want to see trees taken down unless they have to be, and maybe in this case it's a tree that's pretty healthy but in a bad position. But the people who felt more strongly than the majority of us would comment that even though they don't like to see a tree come down, they still supported and stood by Renee's decision. I thought that was very, very telling and very good. That's it.
Okay, thank you, Ann. Any other questions? So now can we move on to Mr. Podwin's time to explain or appeal?
Yeah, sure.
Okay.
Hi, Dave DePodwin here, 33 Old Colony Road. My statements will focus on great concerns for potential property damage, one of both inside and or outside our home, whether it's flooding, erosion, etc. Just for the record, I do feel we've had a good relationship with Ms. Jennings prior to this tree removal incident. She has asked unsolicited for my opinions on various landscaping elements, which I've given her, and she can take them for what they are. But she offered to get my opinion on taking down this subject tree, and that's what I gave her. I did tell her I did not think it was a good thing to do. So in terms of statements and background, as the appellant, my wife and I maintain that the tree removal permit should be retracted as invalid. We are therefore appealing to the council the shade tree ruling that the permit's being upheld. And we're doing this primarily for three reasons. Unfortunately, the first is concern for property damage. Unfortunately, the permit ignores the ordinance with respect to protecting neighbors' adjacent property, specifically 13-8-C. It's totally ignored because a permit says that we will have no soil erosion. My wife and I will have no soil erosion. We will have no sewer problem. We will have no drainage problems. So if permit's been issued, which it has, then the TCO is saying that those things are happening. So that's the first reason, concern for property damage going forward if the tree is removed. By granting the permit, the spirit of protection and conservation, specifically the goals set out in the tree protection ordinance, are completely ignored. They have not been, therefore the ordinance has not been met. And number three, it's invalid criteria with respect to asking for a tree to be cut down for whether it's maintenance reasons, a healthy tree for maintenance reasons, it's dirty, it clogs drains, etc. That is not a reason in the ordinance. So there's three reasons we deem the permit to be invalid. My wife and I have been associated with our property since 1969, having bought her parents' house. The house was built in '51, and we met the original owners of the house. They had told us a couple of years ago that they remember that set of trees on that side of the property when they were here as the first owners. So it's approximately 70 plus years old, at least 70 years old. We have never needed to install a basement sump pump nor a French drain to address any water issues, unlike many homes on Old Colony Road. Given our physical location immediately downslope to the adjacent subject tree, we feel that removal of the healthy beneficial tree will have significant damage affecting on our property, both exterior and interior. We're located mid-hill on Old Colony, where a change in the slope is noteworthy. Groundwater pressure is optimally maintained with this and other trees, and that we believe that this 50 to 60 foot tall, approximately 30 to 40 foot wide canopy tree, which you'll see in the pictures I sent, particular photos 3 and 4 we'll get into later, clearly has shown that it's been successful in absorbing rainfall, stormwater, and mitigating erosion. Three key elements: rainfall, stormwater, and mitigating erosion. It is a wet soil tree, hence the name swamp maple. It's red maples are called swamp maples that provide shade and cooling effect, plus many other benefits, which we all know that trees do. And we believe the removal of the tree and the benefits derived from the tree are inextricably linked. And we contend that removal of the tree will cause damage problems to our property, potentially inside and out. I do have some photos to go into in the way of background. Would this be the time to go through those for point of reference?
Yes.
Okay, first I want to draw your attention to photo 3. Anthony, are you able to show them?
Yes, I can put photo 3 up. Here, give me
okay, it's called, I think it might even be called image 2. It's the bottom half of the tree as taken from my front stoop.
I'm sorry, do you want image 2 or image 3?
Well, on my email to you, it came through as image 2. It's the bottom half of the tree.
Okay, I will get image 2 up. Hang on a second.
It's the U-shaped with a bit of siding of my house, brick and clapboard, where there's a downspout, the one with the downspout on the left. This will be a picture of the healthy tree, the bottom half approximately. It has one main trunk going up maybe 10, 12 feet, and then it branches off to 3 significant large upright limbs.
Is
No.
that right there?
No.
I'm sorry, okay, I'll get the other one.
There's oh, that's the bottom half.
Okay.
The upper half, rather. We're looking for the bottom half.
I'm just cycling through them all here.
Yeah.
This is image 2 right here. Yeah. Did I share it? No. There you go.
Okay, so here's a picture of the subject tree taken from my front stoop. Approximately where you see the grass change to Pachysandra, that's just beyond the Pachysandra, is approximately my property line, on the western end of my property line. And that shows the 3 main leaders, the main trunk, and then 3 main leaders. So that's just the lower half, and then the upper canopy is on, it either comes through as image 3, I believe. Shows a healthy 30 to 40 foot wide canopy. And this tree is approximately, 8 feet maybe from my property line, maybe 6 feet, but with a wide canopy, we believe the roots are very beneficial to the groundwater uptake, which you will see on the, and not the tree on the right, but the tree in the center is the subject tree. If you go next to the water pictures from the 2.5 inches of rain that fell on Friday the 11th, you'll see a wet picture. She comes through as image 1 or image 0 on your file, Anthony.
All right.
And this is viewed about mid-property on our side, in a north-northeast direction towards Old Colony Road. Old Colony Road in the distance. The X on the tree on the left is the subject tree. And then it goes property line approximately along the Pachysandra. And if we can go to the wet picture next. Well, that was the dry side. That was 20 hours after the 2.5 inches of rain. So we maintain that tree has tremendous beneficial value to both properties, not just curbing, not just drains, but the tree itself, which was there a long time, providing good uptake.
I don't know why I'm not able to share the 0, but I will get that.
Okay, so there's a tremendous amount of water around the tree, which has been absorbed over 20 hours after the 2.5 inches of rain. We were interested in knowing how much water a tree of this size absorbed. So we contacted Dr. Abrupta at Rutgers Extension, who referred us to Dr. Jason Grabowski, Extension Specialist in Urban Forestry at Rutgers. And he referred us to the iTree design software.
There it is.
Yeah. He referred us to the iTree design software, which is a commonly used accepted software on determining the uptake of trees. And anyone can go on itreetools.org to run the model, which we did for a tree of this size, approximately 36-inch diameter breast height, approximately. And whether you run it for a little more or a little less, it's about the same uptake. 2,626 gallons a year of rainfall plus stormwater are intercepted by a tree of this kind, healthy red maple. We would like to see this benefit continue and not end up damaging our property, creating erosion and other drainage problems that could potentially lead to costly remediation. 2,600 gallons. And we contest that, in particular, item 13-8-C of the ordinance, where the permit says that we will have no adverse effects to our property as adjacent property owners will be met. But we don't believe that will be the case because the tree has done a tremendous job, as have the other trees in that row, one being the Norway spruce you see there in the foreground. And then there's there's some small ground covers, but not nearly what two trees can take up.
Just to clarify, is that your property that the flooding is on, or is that Miss Jennings' property?
It is both. It's in the low spot between both.
And does the street ever flood? Is Old Colony in that area subject to flooding?
Because we're on a hill, things run downhill, and we're downhill from Miss Jennings. Again, we don't have a sump pump. We don't have a French drain. The trees in that area have handled, water, whether it's a 4-inch event or a 2.5-inch event or, more, it's handled it quite well over the 50 years we've been associated with this property.
And if looking at that picture, is that the Miss Jennings driveway there? Is that the Belgian block of the driveway that she described that I'm seeing?
That is correct.
And this tree that's right in the very front, the closest tree to the right.
Yes, that's a Norway spruce.
That's the one you were referencing. Okay, and
that's our property.
Yeah. By any chance, did you look up how much water that one would absorb?
It's approximately the same age. I did not look it up for a Norway spruce. It's approximately the same size, maybe a little smaller in diameter. We're not planning on cutting it down, so it don't really. I don't think that's relevant for where water is collecting.
Yeah, I see it. I just see it, really collecting more up by the Pachysandra side and more toward that tree rather than the other tree, but not just from.
Well, pictures are tough. You have to really look at the site. Yeah, and just to clarify Ms. Jenny's comment about the tree she removed on the left of her driveway, that would be looking out from her house in her front lawn, not to the left as you're driving in. And that was the tree people she had told us had said that, yes, that was a very healthy tree. And yes, she told me she did have drainage problems after she removed that tree, which she had to remediate. So thank you. We appreciate her remediating those problems. We do wish the healthy tree had stood for a permit granted a year prior.
Jack, am I allowed to speak with and ask a question tying in with DePodwin? Can I make a statement? As part of this?
I'm sorry.
May I make a statement as part of DePodwin? This is Jean DePodwin.
Yeah.
Make a statement. Okay. I'm most puzzled, I guess, by listening to all of this. I'm most puzzled by Renee's comments when Jeff Hammond asked the question, what are the standards that you look at? And, as a layperson in town, I look at the tree protection ordinance and we go to section 13-8, which says review standards. And it expressly states 13-8C about a proposed tree removal not resulting in damage to the property of the applicant as well as to the adjacent property. So I see that expressly stated, and yet Renee, when asked the question by Dr. Hammond, didn't seem to reference that at all. So I'm confused, and maybe Renee could address that whenever it's appropriate, because perhaps we don't understand its relevance in this application. But again, just as a layperson in town, I'm reading that and it says to me very expressly that a proposed tree removal will not result in or cause, increase, or aggravate any or all of the following conditions. And it lists impaired growth or development of remaining trees or shrubs on the property of the applicant or upon adjacent property, soil erosion, sedimentation and dust, drainage, sewage problems, and dangerous or hazardous conditions. So I would like to understand what I'm missing, because to me, that seems to be very contradictory to the decision to cut this particular tree.
All right, so can I speak? This is Renee Apuzzo.
Yes, please. Thank you.
Okay, so review standards, the title of the ordinance, or the title of that particular section is called review standards. Review standards are meant for when it is a site plan in front of the zoning board or the planning board. So in your case, that particular section is not meant to be for this particular permit. So I think this is where, I think I'm constantly trying to explain to many people about the tree protection ordinance, because it is the most confusing ordinance in our code book. It is not easy to explain to a homeowner that just simply wants to take a healthy tree down. So again, the review standard, from my interpretation, is meant for when it's in front of either one of the boards. So you will see that there is various sections of the tree protection ordinance, and it's quite cumbersome when you're trying to then explain it to someone who wants to take a tree removal permit out. And I'm sure that there are others listening that could probably, from their own experience from taking permits out with trees, it seems kind of like this back and forth, just situation, because it's always so different and there's always such a different, unique situation. So in your case, I provided you with the information that I believe you were required to have, which was your obligation to replace 7 trees because of the subject tree that we're discussing. And those 7 replacements are part of the replacement schedule in the ordinance. So why do we have a replacement schedule if we're not utilizing it? So I don't really know how else to explain this. Maybe we could have more discussions at our shade tree committee, but I will tell you that the way that I interpreted it is I approved your permit, you have an obligation, and I provided you the options for the obligation, and I don't know what more I can express.
Renee, I think the person who asked the question was Jean DePodwin.
That's correct.
So you're speaking to Jean DePodwin and David DePodwin, who live next door, not the homeowner who. The question came from the next door neighbor, Jean DePodwin, not the person who applied for the permit, Marla Jennings. The question was asked to you by Jean DePodwin.
So, the answer is that it's review standards. So I don't know, maybe Jack can weigh in on this. Maybe the interpretation has been wrong this entire time with review standards, but I'm just confused at this point because I'm not sure how to help answer further questions, I guess.
Well, I think you answered it directly, Renee. I think you answered the question.
Yeah, I do too.
Is that okay? Is that adequate? It's for the boards. That section is for when it's before a planning board or board of adjustment?
That particular section, that's correct. And there's really nothing in the record that would allow the council to determine whether this will result in drainage issues. You really need expert testimony.
Expert testimony would be required to make that assessment, you're saying, Jack?
Yes.
But to your point, Jack, those are planning board items, not existing items such as we're talking about now.
No, my point is, and maybe Mr. DePodwin is qualified to give an opinion as an expert, but in order to put something in the record that drainage issues would result from the removal of this tree would require expert testimony in order to give that opinion.
Do we know what the replacement plan is? Do we know whether the plan is to replace 7 trees or 5 or 2 or none?
I'm Marla Jennings. I can answer that.
Please.
I plan on putting in 7 trees in that location. So my question is how do we know that 7 3-inch caliber trees won't absorb more water?
We don't.
Exactly.
But
there are calculations for that, and that's not an unknown answer.
7. It's calculated by the diameter of the tree. So
yeah, but
that same website that Dave mentioned talks about that as well.
Yeah, but that's exactly what I was gonna ask. Is the location of the replacement trees specific, or is it just on her property somewhere, or on the same property somewhere, or does it have to be within a certain?
It's not specific.
Well, I think Renee clearly told us what the criteria are.
Yeah.
At least 2 have to be on the property, up to 5 can be paid into the thing, but and they can be placed anywhere on the property. So what we heard from Marla Jennings was what she intends to do, what she's obligated to do is to plant 2 somewhere on her property and pay no more than 5 into the shade tree fund.
Right, but I
Ms.
guess
Jennings just said she was going to put all 7 in the same spot.
That's right. She told us that.
Yes.
yeah, that's right. But I just wanted to see what was the requirement exactly.
But if she doesn't do it, we can't stop her. You know what I mean? She has the right to do something else.
I actually thought I would defer, and the Shade Tree Commission recommended I speak to somebody in town who can help guide me on what kind of trees to get, because I'm not that tree savvy. But to me, 7 trees, 5 trees, whatever would fit there and grow, I planned on utilizing that space. So, I mean, I am very agreeable, and I'm also not trying to dictate, what kind of tree, whatever. I would do whatever is the experts would recommend. But one thing I'd like to say about that picture is it's a little deceiving because that tree is 100% on my property. There is no doubt about that.
Yes,
that
indeed.
large tree is 100% on my property. I think Mr. DePodwin would have an argument if it was kind of on my property and kind of on his. I would see this whole thing totally different. But this tree is 100% on my property.
Well,
So,
I don't know if this has any. Sorry.
Go ahead.
This is Dave DePodwin.
That's
May I
what
make a
plan to
follow-up statement since my name has been used half a dozen times in the last 10 minutes? Yes, it's on Marla Jennings' property. The roots, I'm sure, go on my property. So let's get that out of the way. Number 2, the focus on the review standards. I've read this ordinance 10 times upside down and backwards. There is absolutely no linkage between 13-8 point review standards, section A, B, C, D, etc., to site standards. You may think, you may want, what have you, but the 4 corners of this ordinance do not link that to site development. The section before talks
All right,
about...
can you hold on one second, David? I just want to check with our lawyer. Jack?
I'm just opening up the ordinance. Give me 1 second.
Okay. So,
and if it just is, as he's looking, you'll see, for example, prior to that, in 13.7, it talks about lots not involving a development application. So if it's that important, and if that is the case, and there is a linkage, why doesn't it say that? Because I'm, as a homeowner, trying to protect my property, and the way this is written, I need to be able to protect my property with this ordinance. And the permit requires the ordinance to be met to issue a permit. And Ms. Jennings' rights as the applicant and my rights as an adjacent property owner, and lucky there's only one property owner. What if some of the other 12 who I gave the letters to had a problem and were concerned about the adjacent riparian buffer area, the watershed that we're backing up on in the former wetlands area, the reason that this is a swamp maple, et cetera, et cetera. It is a beneficial tree, and we're using the ordinance to try to protect our property fair and square.
13.8 applies to those applications that are not before one of the boards.
Where does it say that, Jack?
You have to read it in context because 13.9 sets forth the requirements for development applications.
Right, and 13.7 talks about non-site development, not site development work.
That's right.
Jack, what's your opinion? What's your opinion about whether or not Renee's interpretation is accurate?
There's also, if I can just give you one section, there's another section that sets forth criteria to be, hang on, I just had it open, I'm sorry.
But Jack, what you're saying is we can't make that determination if it's damaging a property because we need expert testimony.
That's correct.
But I didn't get a clear answer from you, Jack, from Councilman O'Day's question. Is your interpretation that
is your interpretation consistent with Renee and Puzo?
Or across the board?
I'm sorry, Chad, you faded out there. I couldn't hear your whole question.
Yeah, I was waiting on your final interpretation of whether or not it applies or not.
It applies, in my opinion.
So to complete this, it applies that is only relevant to planning board issues, or it's relevant to all issues regarding removal.
13.9 sets forth those things that are meant to apply before the planning board.
So 13.8 is for items that are not before the planning board or the Board of Adjustment.
That's correct.
Which would apply in this case, except that we do not have expert testimony about the damage.
Where does the burden of proof lie with that, or burden of evidence?
Right.
Well, I mean, even if we did, what would that change?
Now there are other criteria set forth elsewhere in the ordinance, specifically Section 13-7.5, tree removal criteria. And then there's another section down, 13.8 review standards. So I think both of those would apply.
So if let me ask you a question then. If the question hinges upon whether an expert would say that removal of the tree would in fact damage an adjacent property, can we not extend this to allow the Depadwins an opportunity to get an expert if they want to spend the money, hire the expert to come in and make a determination?
I mean, Jeff, for me, the issue is, look, you can find an expert for anything, in my opinion. I'm not sure it would change my mind, so I'm not sure it's worth continuing this process.
This is Dave Depadwin. May I ask a related question that might help this situation? If the permit is being upheld by Shade Tree and the permit states that no adjoining neighbors will have soil erosion, sedimentation, dust, drainage, sewage problems, and dangerous or hazardous conditions, as outlined in 13-8-C, then isn't it incumbent upon the town to send over storm water management engineer Bob Brightly or somebody of that nature, and or somebody qualified on an environmental commission, whoever the logical professional entity is, to make that judgment and uphold the permit because the permit's been issued? I'm appealing a permit that's been issued.
And you need to.
The onus is not on the borough, but the borough, the tree conservation officer issues the permit based on the facts before her. And there's no evidence before her that this would result in drainage problems for the neighbors or on our own property. The main thrust of the tree ordinance is to maintain the supply of trees in the borough.
But what we heard earlier on was that wasn't taken into consideration because the interpretation was that only applied to things before the planning board.
Precisely.
But even if it was, again, it's just one person's sort of supposition against another, just without any, expert testimony.
But it would have changed. It would have changed the dynamics, and it certainly would have changed the appeal process. And for that matter, on Mrs. Jennings' behalf, it would have changed her defense process. She could have hired an expert as well.
So I guess since we're kind of, going around the ordinance here, so 13-7.5 is tree removal criteria. I don't just look at one part of this ordinance. The whole entire ordinance needs to be reviewed. So if review standards is something that's supposed to be reviewed for this particular type of permit, this is news to me because when Lou was here, Matlock, this is exactly how he interpreted the ordinance for the last 30 plus years, if maybe I'm wrong, maybe 20 plus years. So anyways, the 13-7.5 tree removal criteria. Letter F says where the location is in close proximity to a residential structure, that if it were damaged or uprooted as a result of extreme weather conditions condition, such as high winds or heavy snow, it would likely result in a damage to the structure and or injure to the occupants thereof. So with that being said, that is a criteria for removal of a tree. It doesn't say if it's healthy, if it's dead, if it's diseased. So, you know, in my defense of the ordinance, she met the tree removal criteria. So that means I was able to approve the permit, but she still has to fulfill the obligation of replacements and or paying into the tree trust fund. So again, maybe I'm wrong, but.
Wait, let Jack talk, please. Jack?
May I go back to my prefatory remarks? The intent of the ordinance is not for the council to have a full-blown trial. It's really to consider what is in the record and whether to uphold or overrule the tree conservation officer's decision based on what's already in the record. You know, this is not, as I say, this is not a new trial starting from scratch to, you know, make a determination whether there's damage to the adjoining properties.
So at this point, we've heard the testimony from both people. We've read what the Shade Tree Committee has had. So at this point, Jack, this is up to us to decide whether we support the decision or refer it on for further appeal, if that's what they want to do.
Yes, and I think you should give the opportunity, if anyone else wants to be heard, to give those people that opportunity.
Anyone else, meaning who?
Anyone, any resident, anyone in the public.
Oh, okay. Did anyone else in the public want to speak on this?
I see two hands up.
Hands, yeah.
Johanna?
Oh, you're muted. Hang on.
This is Ann Wanzetter. Could I make one remark?
Go ahead, Ann.
Go ahead, Ann.
Okay, speaking for the Shade Tree Committee, of which we have many dedicated and long-standing members going back decades who give on a volunteer basis their time, their efforts, their intelligence. List them right down the line, but I won't. You know who you are. We have over the past year and a half, actually maybe since Lou Matlack sadly left the committee, have discussed, begun wordsmithing. When Dr. Hammond was on as the liaison from the council, now with Tom O'Day, crafted language and given it to Jack Pigeon. It is an ongoing process because we all recognize there are areas that could be improved. There are areas that leave us thinking there's potential for damage here, damage there, situations here, situations there. And so we are working on this. So for those of you in the public venue right now tonight, don't think that this is something that's closed from the perspective of the Shade Tree working at improving and making even more robust in some areas the ordinance. That's it. Thank you.
Thank you, Ann. Johanna?
Yes, Johanna Wissinger. I'm on the Shade Tree, but I'm speaking today as a member of the Shade Tree. And this is my third tree conservation officer that I've worked with. I've been on for a long time. And I'm concerned. I want to support fully Renee. I think that she has addressed this, and it may not be what the interpretation is, but all the while we were with Lou, it was mitigation with the things that the DePodwins have mentioned would become a reality for the Board of Adjustment, or if somebody wants a certification of occupancy. This tree, if we accept the Podwin's premise that it's a healthy tree, any healthy tree that you remove will have an effect, especially on a lot this size. And we have a lot of lots this size. If you do that, you have to say in your ordinance that anyone who has a lot less than a half an acre will not be able to apply, they will be prohibited from removing a tree. Any tree will have some effect. Now, he listed all of them, but most of the effects that we'd be concerned about is water. I very well know the relationship of water and trees. However, when you have a tree ordinance that you want to work with, you have to promote people to comply with it. That's number one. That's the most important thing. And it has to be balanced. And that's what Renee does. That's what the ordinance does. It considers individual home rights. It considers the environmental protection and neighbors. It's tricky. It's not just an environmental view. And I'm really glad that the Podwins considered Chris objected from Rutgers, because I would like someone to look at that tree. That tree is not as glorious as people think. If you go back to that picture, you will see that it has girdling roots. That crown is not what it should be. I don't know why. I'm not an arborist, but I would like to hear an expert really evaluate that tree. That division that you see, that's not good. If you look from her side of it, you will see that large branches have been removed, and that's because large branches have died. You can see them. So I don't have the same confidence and the credibility that that is such a wonderful tree. I'm even thinking that their trees would probably do better. There's no real proof that that water puddle would be taken up by that tree, or that's the only reason why. So I'm really feel as if what Renee did was what she should do. And I think that that's the way it has to be. Especially since Ms. Jennings is going to put 7 trees in, which may in fact be the best thing. There are a lot of aging trees in that whole neighborhood. Not good.
Okay.
That's my opinion.
Thank you, Johanna.
Thank you, Joanna.
I guess next, Peter Birnbaum. You have to unmute him.
Yep.
So the problem that I think we're seeing tonight is one that we've had a lot of, and that is that our ordinances are very, very old from another period of time. But they do have an intention which is very relevant, and that is that people want to be able to take down trees, and that policy is to try to maintain a substantial, consistent canopy, which provides cooling, water uptake, and many, many other services, which are becoming better recognized and more important. So you have, obviously at odds, and that's why we have regulations, and that's why we have, a civil society, hopefully, where we're discussing these things. The trees do provide a lot of cooling. They provide a lot of important services, stormwater management and mitigation, soil stabilization, which are why we have these codes in both the local level and the state level, especially the state level for larger projects. This is also addressed in, I think, many other ordinances in the town in terms of, soil and land and all these different things. But this happened to be the shade tree for this forum. The town is doing passive stormwater management infrastructure projects. We've got 4 that were funded this year, mostly through grants, and many of us have been participating and helping with some of the work. A tree of this size is providing a lot of uptake and a lot of services. We're unfortunately in this place with this particular ordinance because it doesn't really address how to proceed. And I think that the years and years of shade tree work, and no offense, is that it's been very much in the past, and that things are changing and things we've been trying to accelerate over time. And we have, with some extra effort, thank goodness, we're getting there. In the meantime, we have a lot of things that are no longer functioning, and we've got to start fixing them a little bit faster. I think that Renee is absolutely, I have Renee does a great job, and it's an extremely hard job. I think that what we had in the past is that we had not recognized that this is what the Podwins are bringing up is in fact part of the ordinance. and that when you take down a tree or trees, and you can substantially change the neighborhood and another's property. And clearly, when this ordinance was put in effect, it was asked to consider this. And this is what I think the Podwins are asking. I'm not saying there's an easy answer, but it is, and from my reading as well, clearly what is expected in ordinance is someone has to have an ability and a forum to get some relief. And I know that we'll be reading next meeting on this thing to terminate any appeal. I think that's absolutely ludicrous, and I have no idea why that would happen, because who is above the law and who doesn't want to be questioned? It's crazy. But as it may, you have the ability, I think, as council, to turn this back for further consideration based on some of the things that are said tonight, because it appears that they were not done. We don't know if there was a proper vote. We don't know if there was a quorum, and there seemed to be a whole bunch of things that seem to be a little bit out of kilter. And we need to give these people a fair, an adequate response. And as a person on the Environmental Commission, I'm not saying that the Environmental Commission is a place to hear some of these things, but it does have to do with water and stormwater management and runoff, which comes under that purview. And we have a lot of things to cross over. So instead of arguing, I suggest that you turn it back and ask for some more information and a second review of this. I also think that we need to know how many trees have been taken down on that property over the last 5 or 10 years. Because if you had multiple trees of that size, taken down over a period of time, that is an additive effect. And that is pertinent. Thank you.
Okay, thank you, Peter. Terry, you wanted to say something?
I agree with Johanna Wissinger's comments about the shade tree ordinance. And I would also like to say that for like 20 years, I have been concerned about its overbreadth. And I think if this is probably a good time to re-examine the breadth of this, because it sounds to me as though what the Podwins are asking for is official approval of a taking of someone else's property.
Okay, thank you. Did anyone else want to speak? I don't see it. Oh, wait, I saw another hand go up.
Can Terry clarify what she means by what they're asking for is official taking of someone else's property? Can you explain what you mean by that statement?
You're on mute.
Well, I'm Marla Jennings, and I can honestly say that that's exactly how I feel.
Thank you, Marla. No, I was asking. Thank you, Marla.
No,
but I was asking Terry to clarify what she's saying.
They are attempting to control Mrs. Jennings' use of her own property with an ordinance that allows trees, even healthy trees, to be removed without proof, and using the Borough Council to do that. That's what I meant.
Okay. Jeff Price, you want to say something?
Yeah, just Renee, when you met at the site with Dennis Galway, the arborist, he concurred, I think, with most of what Joanna said about the condition of the tree. Is that correct?
That's correct.
Thank you.
Thanks, Jeff. Okay. Anyone else?
Mayor, if I could just add, just to maybe answer Mr. Birnbaum, the appeal process is not going to be dissolved in its entirety. It's simply just not going to be in front of the council. And I know that, what we're discussing right now is the Padwin appeal, but yet on the agenda, the ordinance is to be changed for the appeal process. So I think that's where there's a bit of but the appeal process was just simply to take remove the council out and just leave it in front of the shade tree committee. And maybe Jack could just, if I'm saying it wrong, but that's really what the intent was, not to remove it in its entirety.
Yes, I
Renee,
think the concept is the shade tree committee is best qualified to consider the appeal.
Well, I think the problem is that it's a judge, jury, and executioner in one place, and that doesn't seem wise. Or American.
Well, they still have the option to appeal on the court level. Yes, Jack?
Yes, and in fact, decisions of the zoning officer to appeal those and things involving the MLUL are appealed to the zoning board of adjustment.
Respectfully, the ordinance is up for public comment next week. Can we save public comment for that ordinance next week, please?
Yes, good idea.
All right, so considering this particular appeal that's in front of us then, is that what we're doing right now?
Yes, that's all we're considering.
Yes. So what do we need to do at this point now, Jack? Do we vote? Do we have a...
Well, you need to deliberate. You can do it in public or private if you wish, and decide what you want to do.
Okay. What's your preference?
I don't see any reason to go into private deliberations, do you?
Yeah,
I do not.
Well, I guess I have a few questions for Jack and or Renee, whoever is appropriate to answer the question. The applicant followed the correct process, yes?
Yes. Yes.
Yes.
Okay. The applicant received an approval to remove the tree based on the evaluation of our TCO in consultation with a forestry expert, is that right?
Yes.
That's who was participating? The other person, Dennis, a forestry expert?
That's
He's an
correct.
arborist,
He's a forester.
He's an arborist.
Arborist, thank you. I just wanted to make sure I got the name correct. Okay. So in terms of property rights, Jack, does a person have the right to take down a tree on their own property?
This ordinance inhibits that right. And it was a very controversial ordinance when it was passed for that very reason. And this ordinance is probably more intrusive and goes into much greater detail than any other ordinance we have, including the zoning ordinances.
What was the intent of the ordinance? It's my impression that the intent of the ordinance was that we wanted to maintain a certain quantity and quality of trees in the borough. Is that right?
That's correct. And the impetus for the ordinance was a property owner on the mountain purchased adjoining property and proceeded to clear cut it. So it was very controversial, and that was the impetus to adopting the ordinance back then. And it was really to prevent that kind of clear cutting and to maintain the population of trees in the borough.
Prior to this ordinance being implemented, if somebody wanted to cut down a tree on their property, what restrictions were there? Any?
There were none.
How long has this ordinance been in place? What year is it?
I think the first iteration of it was in 2008, I believe.
That's correct, from what I understand.
And it was totally rewritten by Lou Matlack, I believe, in 2010. And it was originally based on a 10 towns sample ordinance.
Comments, opinions? Anybody?
Jack, you talked about burden of proof previously. Can you reiterate what your position is on burden of proof?
Yes, my position would be that the appellant, the person appealing from the decision of the tree conservation officer, would have the burden to overcome the decision made by the tree conservation officer.
So Mayor, what are you looking for at this point? Are we moving to a vote? Are you looking for further opinions?
If we're deliberating, so we want to get a sense of where the council is on this issue.
My position is clear. I believe that the homeowner has the right to make the change.
And that's kind of the rub for me too. It's just like, as much as I'm sympathetic to the appellant, it's like it's her property, and I think you don't want to create a situation where it becomes you're more incentivized to just get it cut down and pay the fine than to go through the proper channels.
I think everybody's respectful of property rights, but that works both ways. And if
it's more clear cut for me in that it's her property, and it's
let me finish. But if the situation were that the removal of the tree were proven to be detrimental to the adjacent property, that creates a problem. And I'm sure if it was your property, you would feel the
You also
same
don't
way.
want to create a situation where people can belabor things by, just appealing and appealing. So it's, I have to pick a side and I have to come down on the rights of the property owner to kind of augment their property to their taste.
I think,
and I concur. If this tree somehow crossed over the property line, I think it would be a completely different discussion. But for me, this seems to be a fairly cut and dry situation of a property owner taking down one of.
Well, I think we also heard from the Shade Tree Committee, and I think it's relevant to the discussion, was the idea that, you can't not remove a tree from any property that doesn't impact water and erosion and everything else. Every tree will. A small tree will, a large tree will, they all will. So if the ordinance is written that it can't have any impact, that means that no tree comes down ever.
Agreed. And I don't think that's a town that, that's
right, but at some point, the impact may be significant. I mean, it could be.
But that's the burden of proof question to me, Councilman Hammond.
Okay, and then what I'm getting at here is that I'm not sure it was made clear. Listen, I'm sympathetic to Jennings, but I also want to be fair, and I'm not sure that the rules were clearly established and that the Podwins knew that their word for it wasn't going to be taken. In other words, we had to have some sort of, they had the opportunity, in fact, the obligation to provide some sort of expert analysis of the drainage.
Well, I think the other thing is that was brought up by Marla Jennings also was the discussion did not take account of the fact that if you replace 2 trees, 4 trees, 5 trees, or 7 trees in a similar location, that it does mitigate any negative impact of taking down the one tree as well. So if any expert is going to look at this, I would say they have to look at, both sides of the equation.
True, and I'm encouraged that the intent is to put 7 trees back in. However, the applicant has a year to do that and can change his or her mind. So 6 months from now, they can say, you know what, I don't want to put any trees. I'll just pay the fine, which quite frankly is probably less than putting trees in.
Christine, you want to weigh in here?
I have to say that I agree with what Johanna said about not wanting to set a precedent for people to think that I better not apply for my permit because then my neighbor's gonna dispute it. I'd rather just cut the tree down and deal with the consequences later. That's a behavior that we don't want to see, and that's kind of what worries me. We heard from the homeowner that she went through all the proper channels and did this the right way, and if she puts the 7 trees, like it sounded to me, that's what she really wants to do. She doesn't want water problems on her own property either. So after hearing what she's saying, and I agree, I feel for the next door neighbors, the Podwins, but you have to put yourself or try to put yourself in both positions. Is my earphone freaking out? No.
No.
So it's a tough one, but I agree with Renee's decision. I think what Johanna said made a lot of sense, and I'm hopeful that the situation can be resolved by whether it's more trees or a rain garden, or there's tons of ways to mitigate water that that can be used. And
thank you. Okay, Gina, we didn't hear from you.
I mean, I'm certainly no tree expert, but just hearing and listening to all the sides, I think I'm in agreement that the property owner has their own right to follow their process, and that Renee and Dennis did their job in their due diligence and what they interpreted the existing ordinance. If the ordinance needs to be rewritten, that's a different topic.
Thank you.
Can I just make one last point, Mayor? I haven't said a lot during this. Is that okay?
Yeah. Go ahead.
I've had Renee over to my property personally because we had to take down a few trees. I have no question in my mind that every time she walks onto a property, she's doing so for the best of the environment. And actually, I remember her trying to talk me out of taking trees down. I have no issue with the motive here. And I fully believe that Renee is not only acting in the best for our town, but also in doing so, she's trying to preserve something that I think she's important, which makes her perfect for this job.
Thank you.
I would agree.
Yeah. So do we hear from it? It sounds like we have consensus on supporting the shade tree. Do we need to?
I would do a motion to affirm the determination of the tree conservation officer in granting the permit to Ms. Jennings to remove the tree.
Somebody would like to make that motion?
I will make that motion. And Jack, you talked really fast. I wasn't able to write down.
Oh,
Can
sorry.
I make the motion of what Jack said?
Yeah, to affirm the decision of the tree conservation officer.
Very good.
To issue a permit to Ms. Jennings to remove the tree.
I'll make the motion to affirm the decision of the committee for Mrs. Jennings to remove the tree.
And I'll second.
Okay. Do we need a roll call?
I would do a roll call. Yes, please.
Yes. Okay.
Mr. Donahue?
Yes.
Mr. Hammond?
Yes, and I hope the 7 trees get planted.
Ms. McCready?
Yes.
Mr. McQueen?
Yes.
Mr. O'Day?
Based on the recommendation of our staff and the Shade Tree Committee, I vote yes.
Ms. Zamara?
Yes.
Okay. Thank you. So I guess do we need to put that in some kind of a formal letter?
It will be in the record. It will be in the minutes.
Okay. All right. Thank you all for your time. And now we are moving on to 10B, the borough policies.
So can I just, before we go to, since we're going to be considering the shade tree appeal process at the next meeting, is it possible to clarify that the issue that we were talking about, whether the stipulations, which there was a debate about whether they applied to only issues going before the planning board or not, that gets clarified as well?
I'll take a look at it.
Okay.
Thank you,
And
Jack.
Jeff, along that lines, I'll be honest, I had thoughts many times during this discussion tonight. You know, you and I have worked, and I know many on the council have worked to help to modernize and update ordinances. Renee, could you provide your advice along with Jeff and the rest of the Shade Tree Committee if there are any modernizations that are needed to the ordinance itself?
So we actually have been actively, trying to modify the ordinance for some time now. And I honestly think with the COVID-19 really just kind of stalled, a good amount of our time that we would have been spent, getting this ordinance revamped. As we all know, we've done some changes in the last, I think, about 2 years. But obviously, I think 2020 was really when we wanted to get things moving even farther with the ordinance. And, this is just kind of a prime example. There's just, it's just kind of been put together, like Jack said, with many different towns. We just need to really make it more unique to Bernardsville and how the shade tree feels it needs to be revamped, and maybe getting some resident input at this point in time would be a great way to move forward.
Right. And I think you need to have the philosophical discussion as to whether you want to micromanage to the extent that this ordinance does.
Right. It's quite cumbersome with the responsibility of,
it's
the
like,
tree
it's like
conservation
27
officer.
pages.
It's longer. It's like longer than the zoning ordinance.
Yeah, basically.
So yeah, it's definitely been on our minds. It's been a discussion. Now I think this is just a much more thorough way of saying we really need to get on top of it so we can best provide our residents with good language and easier to provide them with what is expected of them to take a tree down and et cetera.
Okay, good. Thank you. Okay, so borough policies, Ralph, I know you were working on these with our attorney on
Yes.
the new travel regulations and.
Yes, yes, you have, I've copied 3 of the um, proposals, the letters, actually that one was written for me. John McDowell has put one together for the Public Works Committee. John, I'd like to start with John's first, and the chief has been working with Lisa Barry Quick also for the travel ordinance that the governor, or not the ordinance, the travel restrictions that the governor has put on all of us. And he's here with us too to go over. He's had the opportunity to issue an order in working with Lisa. So I wanted him to explain that himself. I didn't want to speak for the police department, but I'll go through these 3 items that are pertaining to the rest of the borough employees other than the police department. The first one is from John McDowell. This is just a draft, but he wanted to run that by me, and I wanted to run it by the entire governing body. It's for a little further clarification for Public Works employees about the initial policy to reopen and bring back the borough employees, the COVID policy that we put together back about a month and a half ago. And it's, it's kind of self-explanatory there. I'm bringing it before you for comments, for suggestions, for deletions or additions before we send it out. And that, again, is self-explanatory there. I'll just go through these documents and then we could start the discussion. The second one is an email that Lisa put together for my signature, basically outlining some of the particulars of the travel restriction that the governor has put on us. And again, there are some options in these next 2 things under this order from the governor and what can be done for the employees that I'd just like you to consider. There is the COVID-19, there's an acronym for this, but it's basically COVID acronym. This is expected for self-quarantine, the 14 days when you come back from a trip. Anybody that goes to any of the states listed here has to come back and be quarantined for 14 days. And the question is are we eligible to do this with pay, with personal time, with sick time, can do it without getting paid at all, unpaid leave, and there are a number of options for it. In the COVID-19 section for all employees, anything related to that is if it is rated to COVID, you could, and you meet the criteria, you could have your 80 hours of time paid for. That is an option there. Again, another option is that you take personal time for those 14 days or 10 days, work days, or do it without pay. And the third document is more detailed. It basically says the same thing. It gives more details. This program that was ordered by the governor way back when this started is the Families First Coronavirus Response Act. And that is the one that would allow 80 hours of time paid for by the municipality or by the entity, not only to public, but to private sectors. Rick Mickles, our dispatch that we had, the first incident that we had to deal with Lisa and go through the process, did meet the criteria, and his first 2 weeks off were under that part of the law. Once that's done, you cannot utilize that again. It's a one-time thing. That's also something you should be aware of. And again, the rest, this is a much more detailed one, but the one before that was something I wanted Lisa to put a little more easier to read for our employees. But I did want to get something out to them within the next week or so. If in fact you agree with what this, in concept with what's here, I'll do that, or we can wait until August. But in the meantime, I need to give employees some direction when they want to take, if they want to go ahead and take this vacation, and so does the chief. And as I said, Kevin will tell you what he's put in his order. It's basically the same thing, but I wanted to make sure that we ran this all by the governing body, all of you, so that you understand what we can do, what we can't do, and how you'd like to proceed.
I mean, discussion?
Yeah.
Okay. So, I mean, I'll say, I think I agree in principle, like you said, with what's here. Some of the, actually, there's just one that I think is contradictory with what else is being said. So the first bullet on the for DPW employees, it says, when working outside, as long as you're able to maintain an excess of 6 feet away from other employees, you do not have to wear a mask. But the which bullet is it? It's the, it's the one that's when you're talking about walking to your car. Here you go. The third bullet. When riding in a borough vehicle alone, no mask is required. However, when walking to or from the vehicle, a mask or face covering is required. I feel like if you're not within 6 feet of somebody, that's the first bullet that says that. But then this one says when you're walking to your car, you have to wear it. Could see if you have to drive with somebody and you're both walking together and you can't maintain your 6 feet, that's one thing. But if you're just walking to your car and there's no one else in the parking lot,
right?
I just feel like they're a little contradictory to one another. I mean,
okay, I see your point. Again, that's why we're trying to go over this in as much detail, because we've received, just so you all know, Anthony and I have received a number of questions and a number of concerns since everyone has come back to work in the borough for explanations about this, how to proceed in certain situations. And we've been in contact with Lisa Barry Quick very often in these last, I guess it's been about 5 or 6 weeks now that we've had everybody back here. So it's still a moving target, unfortunately. And the future looks like, if these cases continue to spike up, I don't know how tight the governor says he's going to, put restrictions on, tighter ones that we've got now. So it changes. I
think we just tweaked the third bullet, Ralph, and to consistent with Councilwoman McCready's point, we just tweaked the third bullet that would address the concern, I think.
Okay.
Yeah, and I'm fine also with them using the Family Cares Act, or whatever it's called now, the FFRs.
Yeah. Yes. Yeah.
I'm fine with them using that time. I don't know how everybody else feels about that. But I think, is there anything, I didn't see anything quickly written here in these policies about using your vacation time per normal vacation policies. Like the standard vacation policies are not going to be updated due to COVID. So I think people were asking, are we going to extend the time that they had to use their vacation?
Oh yeah, no, that's a closed item. I was given instruction. It's got to be 2 months ago. I guess it was one of our first Zoom meetings that the end of June would be a 30-day. That's normally what I've done. The ordinance does say that I can extend things, and I've never extended it past the June 30th. And that was the direction I was given back when, and all that unused vacation from 2019 has been used. So that's all done, Jenna.
I just have one question before we move on the FFCRA.
Mm-hmm.
So if I understand this correctly, so Ralph and Jack, so if somebody decides to go on vacation to Nevada, I just chose one, right?
Mm-hmm.
And then they have to quarantine, and if they're unable to work from home, are we required to provide leave? Because it's not like this is a man. This isn't a man. Somebody's getting sick. This is a personal choice to leave and go to a quarantine state.
Mm-hmm. I've asked that question a number of times, actually, because I want to get it straight. Because it's the first responders, really the police department and the road department, that have that. They satisfy the requirements for first responders, and they are the ones, especially the road department, that has the least amount of ability to work at home. Obviously, there are some things Kevin and I have been chatting lately, and there may be some things that some police officers can do from home, and satisfy our work from home situation. But the road department, basically both of them as a whole, come under that category. And back when Jack, you helped me with this, we exempted, or maybe Kevin, you could jump in too, we exempted the police department from that qualification so that they could receive those benefits. Is that correct, Jack? Way back? Oh, you're on mute.
Yes.
Yeah,
this seems to be a different
That's my
circumstance.
recollection. It was Lisa's advice, yes.
Yeah.
Yes, so that was done then.
Yeah.
So Lisa has advised me that, in fact, that can also work for the governing body, so that the police are not qualified to do this.
Oh, so this isn't just for the police. I believe this is for all borough employees, correct?
Well, the borough employees that can work from home, okay, and basically all of us that were working during, the 2-3 months that we were closed, if in fact they leave, we are obligated, if they can work from home, to let them work from home.
Right.
So if somebody goes to, and so this is an important distinction.
Sure.
I don't think we should make a distinction based on what your job function is. So this is not a circumstance where somebody's becoming ill. This is a circumstance where somebody's making a personal choice to go somewhere on vacation and then return.
Yeah, but sorry, Chad, I think we need to make a distinction there, because there are so many states that are being added to this list daily. Somebody could be gone right now and their state gets added to the list, and by the time they come back, now they have to quarantine. So
I think that could be an exception, but I think Chad's original point, which he hasn't finished making yet, but I think I know where he's going, is if somebody says, I'm going to go to Walt Disney World because they reopened, spend 3 days at Walt Disney World, and then come back and take 2 weeks because they can't come back now because of the quarantine requirement, they can't come back to work. My question is along Chad's line. If that was a choice to go to Disney World, nobody, the borough didn't direct you to go to Disney World.
And thank you for finishing that for me, because that's not, frankly, a choice that I support. I mean, we all make personal choices in life, and personal choices often have secondary downstream effects.
I'll even take this a little bit farther, because I'm opposed to this plan. We are giving permission for people to go to a quarantine state. That's what this says. It says it's okay by us if you go, because all you're going to happen to do is put your vacation time at jeopardy. But what happens if somebody goes and gets sick and they're out of work for 6 months, which is not an unreasonable thought? That really impacts the borough. I don't think we should be allowing people to go to quarantine states.
Well, I don't think we should be determining that, but we shouldn't necessarily facilitate it. I don't know that we should
or incentivize it.
Yeah. Well, I have a different question for Ralph.
Mm-hmm.
The Family First Coronavirus Response Act says that we pay up to, is it 80 hours?
Yes.
People who are exposed unintentionally through their work or home or school or whatever, they got exposed, they have to self-quarantine. The Family First says we'll pay them 80 hours to stay at home, correct?
Yes.
Okay. If I as an employee have 40 hours of vacation in my bank this year,
mm-hmm.
and I have to stay home because I was exposed at school, let's say,
mm-hmm.
Do I use up my 40 hours that I have accrued, or I use 80 hours that previously didn't exist until the FFCRA came through? Like, where are these hours and this money coming from to pay for these 10 days at home.
Right.
Where does the money come from?
Ralph, I think I can help you with that.
Thank you, Kev. Yeah, sure.
So first, let me start by saying I think both Ralph and I were somewhat reluctant to have this conversation tonight without, our legal counsel, Lisa, being here to answer a lot of these questions. So I'm going to frame my responses in terms of what I understand them to be based on the conversations that I've had with Lisa, other people in the field, and quite frankly, the county prosecutor as well. To answer your question, Chad, I think that we, or Tom, who asked it, we can't tell people what they can do in their own time. If they want to travel to one of these states, we do not have the authority to tell them they cannot go. What would be concerned, whether it's right or wrong, and I'm not making an opinion here, but I understand your concerns with that. When they return, though, however, when it comes to returning back to the workplace, there are a series of options that are available to the employee and the employer as to how we handle these matters. The employees have accumulated time, whether it be vacation time, personal days, comp time, that they can elect to take off if they want to. They also have their relief, their 2 weeks of relief time, their COVID-19 relief time that they can use for 14 days. They get, there's a maximum amount that they can be paid for each day. It's $500 and something a day of a benefit that they get if they opt to use this time. They only get it once. Once it's gone, it's gone up until the end of this year, December 31st. And if they need to quarantine or self-isolate again, this time does not repeat, it does not recur, it's used. And they have to find some other time that they would use, or possibly take unpaid leave. There's a variety of options that they have, and we can provide them with them options. And one of those options is working from home if they can as well. The key here is that they're not returning to the workplace for 14 days. Mm-hmm. So if I can go back for a minute.
So Kevin, who pays the FFCRA amount? Who pays that?
The borough does.
The borough pays for it, and it's not reimbursable to us through the CARES Act or anything else?
Somerset County, at this point, Somerset County has not been included in the CARES Act. I did send something to the mayor about that, where the county freeholders were joining with some other counties that were opted out or written out of the CARES Act benefits because of the population of our county when they distributed those funds. But no, the CARES Act funding is not available for that. As far as I know, the FEMA funding that we're applying for also does not cover overtime due to absences. It only covers overtime that has to do with response, basically, so, and specific steps and things that we do to combat and respond to the COVID-19 emergency are reimbursable by FEMA. So it's my understanding at this point that this was legislated, and the borough is responsible for paying for this, but perhaps there's some backdoor funding that comes back to the borough. I suppose Lisa could answer that better. I really don't know, and I don't want to step outside of my area of knowledge, so to speak.
I'm reading the attachment. Sorry, I'm reading the attachment 10B, and it says here, I don't know who typed this. For those who cannot work from home, they may be entitled to utilize emergency sick leave. Where does the may come from, and who wrote that?
I think Lisa wrote that. I haven't seen that. I wasn't involved in the draft of the policy that is being considered for the borough employees. But I think that may comes in that we cannot force them to use their Corona-19 benefit time. We can't say.
Well, no, they may use would be correct. This says may be entitled, which implies they may not be entitled. So that's my question about that wording there.
Well, I don't know. I mean, it could be maybe aren't entitled to it because they've used it already, depending on if it's their first time or second time. I really don't know the set of circumstances. I don't think every absence or every travel to one of the quarantine states where you return is specifically going to require that you use this time. The time may not be eligible for you, depending on the circumstances. I don't know, why that term is in there. Again,
Well, and Chief, that's my.
I'm sorry, Kevin, if I could
question,
jump in on that.
Look.
Oh, all right.
Sorry,
All
Rob?
right, go ahead.
No, go ahead.
Tom, I think I could help you with that question. Lisa basically was saying that the council can choose not to allow this to happen with the employees that are basic in the first responder category, doing the opposite of what was done 2 months ago when they were exempted out. So that my understanding is that that's a choice that the governing body can make.
So we can choose
And Ralph, just to be clear, that's not what's being positioned here. The fundamental question that I have is if somebody goes on vacation and comes back and is quarantined, whether or not the FFCRA even applies. And I think probably the only person that can say that, let us know, is use sick time. There's a lot of other avenues.
We're losing you, Chad.
Yeah,
You're breaking up, Chad.
I need to understand if FFCRA even applies. Oh, sorry. Can you hear me now?
Yes, better.
Yes. Yeah, sorry. I just need to understand. I think my internet connection is slow here. If the FFCRA even applies for a voluntary item such as leaving the state, because right now, I got to be honest with you. I mean, if you leave the state, you're taking a lot of things into your own personal hands, and I'm not sure that it's your employer's problem.
Well, what if you already had a commitment? You have non-refundable tickets, that you booked 6 months ago.
Nothing is non-refundable right now. All airlines have offered free refunds and reschedules, and hotels have.
Yeah, but if you leave, if I go now, right, if I don't knowingly go to North Carolina, if I go to whatever, one of the states that are not on the list, and then all of a sudden it comes on the list while I'm there during that week or 2 weeks or whatever my vacation time was, and now I come back. I think that's the only
exemption. Yeah.
And what would your employer say? Your employer say you're going to take paid time off. I mean, you're going to take vacation time, or you're not going to get paid. I don't think Novartis is going to say.
Yeah, no.
Go on another 14 days off because the choice you made. This is my personal.
Well, I can work from home. I think that's where Ralph's, first responder thing kind of came in, because all the other ones can work from home. So I could continue to work from home, and I'm self-quarantining at the same time. No big deal. But I think there's one other exception too, or something we should think about, I guess, in consideration of all this, because I heard somebody say, well, what if you drive to Pennsylvania, go to Philly, then you fly down to North Carolina, then you fly back into Philly, and then you come back to Jersey? Well, technically I came back from Philly, not North Carolina.
Quarantine only really if you had spent overnight in Philly, but if you're just passing through in transit, that doesn't apply.
Yeah, so I'm just saying people can start to get creative, I guess, is my point.
Didn't hear that one.
I'm just more concerned about somebody going off and getting sick. It's one thing to stay self-quarantine, but we lose an employee for 3 months. That has a direct impact on the borough.
I think if employees have their own time, they can do what they want with their own time. I think the real question is whether or not we provide an additional 80 hours of paid leave on top of their earned time, for the circumstance.
I'll dispute that people can do what they want with their own time, because I think as public servants, we all have a different obligation. It's not a private company. In fact, if it was a private company, it'd be simpler. You'd just be told you're not going to do that if you want to work here. But I think that we have to, we're talking about a pandemic. I think it's irresponsible to go to a quarantine state.
Can we take a step back here for a minute?
Yeah.
Obviously, this is the first time I think that as a council, you've had an opportunity to consider this and discuss this. And, our opinions and feelings are all over the place about whether this is right or wrong and what we can do and can't do. There is a lot of guidance out there on this already that I'm not sure that council has seen. That I think before we determine what the right thing or the wrong thing to do would be to consider all of the guidance. We've been dealing with this in the police department since July 2nd. When this quarantine order came down in the form of an executive order, we immediately realized that there could be a backlash on critical infrastructure personnel, police, fire, EMS, DPW people, who are all specifically listed as critical infrastructure employees. There's various different categories of those critical infrastructure employees based on Homeland Security guidance documents that are out there. To our primary concern, or the police officers in the borough and or DPW employees fall into the category of critical infrastructure employees. The Department of Health, the State Department of Health, has issued a guidance document that exempts critical infrastructure employees from the requirement of a 14-day quarantine. So there are exemptions for certain types of travel. Certain business travel is exempt. Certain health care travel workers are exempted from quarantining. Law enforcement officers are exempted from quarantining. That creates a concern or a question as to how do we protect our workforce when somebody who travels to one of these quarantine states returns. And Lisa, I'm not going to go into detail here in a public meeting, but Lisa and I had extensive conversation back and forth about how the best way to handle this inside the police department with regards to a policy that we came up with should be issued. I will tell you that there are multiple different policies and different critical employment agencies. I'm more familiar with the police ones. They're all over the board. Some people have adopted policies that say if you had a previously committed engagement where you were financially obligated, you could go and you would be allowed to quarantine and you would not be penalized any time upon your return. Other agencies have implemented medical monitoring, required negative COVID tests, and put self-monitoring procedures in place for people who leave and then return but do not have to quarantine. Other agencies have come up with a hybrid of quarantining until you get your positive test and put in implementations or guidelines as to what kind of time you can use while you're waiting for your test results, and then what kind of time you have to use if you test positive, and then if you don't test positive, if you test negative, the conditions and how you can return to work and what your duties and responsibilities will be. The responses are all over the board. So, without Lisa here to answer some of these questions and without, I think, council being fully informed of some of the guidance documents that are out there, it's really difficult to say at this point what we should be doing and what we can do or cannot do.
If we put the decision off from tonight, Kevin, then it's another 30 days. What happens for the people who are on vacation during those 30 days?
We could schedule another meeting. We could schedule an emergency meeting to discuss that.
Tom, you don't have all the information. I think that you need to make an informed decision right now, and I can't provide it to you at this time.
I think it was well said, Chief.
Kevin, if I could just jump in for a second, I concur with Kevin in his thoughts that we don't have. There's a number of different things. Lisa has gone over all the different areas and possibilities with me also, but I wanted to get this out in front to you, and I've been taking notes here to answer some of the questions that you're bringing up right now, and try to get some advice and try to get answers for you. Now, Jack, I know I can't, well, let me ask you this. Well, Jack, no, I think I know the answer to the question. If I get answers, I can't send that around and get it. No. I mean, if we could, I could certainly get the information back or have Lisa on. I could get her on just for a meeting like that. It could be in the morning if that's, if that's amenable to the governing body.
Can I ask a procedural question here?
Sure.
Mayor? Aren't these exactly the types of things that should be going to the personnel committee? And then coming to council once, because we would have asked the appropriate questions at that time with then the appropriate information coming to council for deliberation. Isn't that the appropriate channel for these types of items?
Yep, makes sense.
Yeah, I mean, I was going to ask a similar question, but just to say, can the personnel committee just do it rather than trying to get a special council meeting?
Well, you could do that.
Yeah, you can delegate that to the personnel committee.
It's just the amount of time, like how much time do we have to make this decision? If it's personnel committee can meet later this week. So if you meet this week and then make a recommendation, we have a meeting next Monday, those if you remember, to do our vision planning. So maybe we could, start a half hour earlier and, hear the recommendation of the personnel committee and get that out of the way.
Is that legitimate, Jack, or did it have to be on the agenda when we set that meeting?
I don't know if we said it yet. Did you send
We
it out?
didn't set it. Anthony still has time to send out a notice.
I didn't do the agenda, but I sent out the notice, but I could revise the notice just to add that topic.
Right.
So yeah, the agenda is not done for that though yet.
So the proposal is that we'll ask the personnel committee to meet, evaluate, and make recommendation for us, the full council, to review on Monday.
Yes.
Can I just comment on some things that were said earlier? I didn't get an opportunity to say a few things. One, there's a lot of reasons that somebody might have to travel to the state that is not necessarily for pleasure. It couldn't be a death in the family. It can be an illness in the family. It can have something to do with children going off to school, whether it be, private school, public, college, or universities. It can be to tend to property matters, estate settlements. There's a variety of reasons that somebody may not really have an option to not go to one of these quarantine states, even though they would rather not. So we can't assume right away that everybody who's going to be traveling to one of these quarantine states is going to go to Disney or Las Vegas or going out to have a reckless blast, because I don't think that anybody wants to do that. So I think you need to have considerations for those kinds of situations, number one. And then, number two, there are exemptions that have been made for certain employees that they're saying that they're exempt from the quarantine rule. One of the things that some of the agencies have done is they've put medical oversight and medical monitoring in upon return, as opposed to a mandatory quarantine. That's a possibility. It's been done in other communities right here in Somerset County already, but other people have taken a stronger stance as well. The council decided to exempt police personnel and first responders in the borough, or to not exempt them. Actually, it's kind of like a double negative, but I think you decided to not exempt them, which entitled them to receive those corona benefits on the thought that they're needed here, and that if they get exposed as part of their duties or as part of work, they need and should have, rightfully so, 2 weeks to quarantine, isolate, do what they need to do, and not be penalized for that. And that was, I think, the mindset of the council at the time when you afforded that benefit to our first responders. Now, who would have thought that there would be quarantine orders in place where there are travel restrictions, and they're only advisories. When someone returns from one of these 14 states, the executive order says you should self-quarantine. It doesn't say you must. The borough policy that's been proposed, and the one that the police issued, that I issued for the police department on Lisa's guidance, said that they must, supply certain information, and that they must quarantine. My draft had a medical component to it for medical testing and observation and safeguards in place that were, upon advice of council, removed from our version of the bill, basically giving them the option of staying home at work and working for 14 days, taking personal leave, taking unpaid leave, or using their COVID-19 time. We can't tell them what time they have to take that 14 days, but we can tell them if we feel it's appropriate not to come to work, or we can find work for them to do from home. So there's a lot of options here. What I would suggest is that you look at the Department of Health memo that's been issued. I would suggest that you look at the CDC guidance that's out there for employees returning to work who have been exposed. There is specific CDC guidance in place for that, and it does not necessarily, off the top of my head, require quarantine in all cases. There's also Homeland Security guidance regarding critical infrastructure sector employees. That leads to some of those exemptions that we talked about. We have a policy in place already in the police department, and there are other policies and other agencies and police departments in the area that have also already been put into circulation and into effect. So, you know, before we suddenly decide that we don't want to afford our employees any of these COVID-19 benefits, I would just ask that we step back and we think about some of the reasons that somebody might have to travel to one of these states when they really don't want to. And why should we be punishing them for that when it's not really something that may necessarily be within their discretion to say that they're not going to go.
We can certainly build in, and you're absolutely right. I mean, there are funerals and there are legal obligations that people have to attend to, and we can certainly build that into a policy. But I'll argue with you that people don't willingly go to a vacation spot in a quarantine state, or else we wouldn't see the beaches in Florida and Texas being packed. I just think we have to be realistic. We have to be realistic, and it's not just about quarantining because you've been exposed. My concern is that we lose an employee for a prolonged period of time, and we can't replace them, and that has an impact on the function of the borough.
Nobody wants to lose an employee for a long period of time. All I'm suggesting is that we not jump to the conclusion that the reason, you know, I think we need to give our employees a little bit more credit than that, to be quite frank. And, you know, I know most of my employees do not want to go somewhere where they're possibly going to infect themselves and ultimately infect their families, because they're very concerned about that as well. So, yeah, we have to have safeguards in place. We certainly have to have a policy in place. I agree with you. But I think we need to work with our employees, and we need to understand that there are certain exemptions that the borough may or may not have control over when it comes to quarantining certain categories of employees. And that is still, I can tell you right now, being legally discussed and legally debated as to exactly when those exemptions apply and to who those exemptions apply for, although there are specific categories where they're exempt. I think the question comes into the extent of the exemptions or when they apply. And I have not been able to get clear guidance on that.
Yes. So, can we get the personnel committee to meet this week? Ralph, can you get them the CDC and Department of Health guidelines, whatever background information that they can review?
Sure.
And maybe have Lisa in on their meeting?
Yes, absolutely.
And that way they can bring to us on Monday when we have our meeting. Maybe if we start at 6 o'clock instead of 7, take the first hour, get this done. We'll have a certain, you know, a confirmed end time, and then we'll do our planning at 7. Does that work for everybody?
That's fine by me.
That's one thing I wanted to follow up on. The chief rightfully talked about how we as a council wanted to be as generous as we could to our first responders and I think the category was called essential personnel. I don't know if it was all first responders, it was essential personnel, the label that was used in the FCCRA guidance. But I think the other key point, and the chief said this, is that we were concerned that somebody as part of their duties would be exposed, and through no fault of their own, because they were following guidelines but doing their job, they got exposed and then had to self-quarantine for 14 days, that we did not want them to not receive the same benefits. Even though legally we could have said that they were exempted, we decided to make them non-exempt. I think that's the wording. But the key to that sentence in my mind is as part of their duty. And I think what we're talking about now is something that's outside the scope of somebody's duty. And whether or not that non-exempt status should apply in those circumstances, which are different circumstances than we considered previously.
I think I agree with you, Tom, on that, but I think we have to be mindful of the fact that how do we know when and where someone was actually exposed? How do we know they weren't exposed at work before they left for their 14 days? If they're not,
well, they wouldn't be required to quarantine then unless they had symptoms. This quarantine is different from prior quarantines. Prior quarantines are if you were asked to quarantine for 14 days if you had a known exposure. So, for example, somebody you work with, your partner or someone came down with a positive test, then you'd be asked to self-quarantine. You don't have any symptoms at that point, but you have a known exposure. So I think what this is saying is if you travel to Florida or South Carolina or Texas right now, that's basically a known exposure. But the question, I think, really is whether or not, and this was, you touched on this as well, Chief, was whether or not that was a discretionary, exposure or whether it was, less than discretionary.
Yeah, no,
I know that the entire nation had funerals canceled outright. I know people personally who were unable to attend funerals even in their own home state because of COVID-19.
I understand. So, I understand completely, but I think we need to be mindful of the fact that there really is no way for sure that we know when and where and how somebody's exposed. You can say, look, it might be likely that you would be exposed, but somebody could travel to a state, basically isolate, not have contact with anybody, do what they have to do and come back. It doesn't necessarily mean we need to assume that they've been exposed. I know.
Well, that's the guidance from the state of New Jersey, I think.
Yeah. No, it's not. Well, the guidance says that we should self-quarantine.
Right.
The borough is saying pretty much that we must. So, maybe there's other things. There's other policies that are out there, other considerations.
Can I just clarify? When you say the borough is saying we must, aren't we debating that now? And the must question, whether or not the borough, that's not been decided yet, has it?
Well, it has with regards to the police policy. That's already been issued because, we were on the front lines of this. And we started talking about this back on July 2nd, as many other first responder agencies did. There were models that were flying around all over the state about how different law enforcement agencies were dealing with exactly this matter. The exemption, when the exemption takes place, do they have to quarantine? Do they not have to quarantine? Do we require testing? Who pays for the testing? All of these things were being considered, when the executive order, almost a day after the executive order was issued, with no warning whatsoever to any of the first responder community. Our policy calls for mandatory notification prior to leaving the state. You have to advise us, the supervisors, of where you're going, the extent of your travel, and the reason for your travel before you submit your leave of absence request. The state has, we'll be updating the list of quarantine states on a daily basis, basically. So that's kind of a moving target there. That list is subject to change, and we need to know where and when our officers are traveling. It doesn't matter. They're allowed to travel through states, but they're not allowed to visit states. So you can travel through a quarantine state, and the quarantine doesn't apply if you're merely traveling through. You can stop at a rest stop. You can use facilities. It doesn't say what you can do and can't do when you're traveling through a state, but your ultimate destination, I think, is what they're referring to as the quarantine state. So there are provisions in our policy that when you return, because you're being required to quarantine, then we go into. I'm looking at this now. There's a lot of strikeouts here on the original draft. I can give you a copy of what we've crafted to date, but I will tell you that it's already being subject to change. And as Lisa, I think, made a comment about the road department, a lot of this is negotiable about what time they use and how they use it. I think we have a lot more latitude. The borough has a lot more latitude with regards to the non-contractual employees, but for the contractual employees, I think there needs to be some considerations as to what we can and can't do here, and what's in the best interest of all of our employees. Hopefully, we can strike some kind of a reasonable understanding with everybody. And look, nobody wants to get sick, and I think we're all on the same side of this battle, is just how we're going to accomplish our our mission to keep everybody safe and secure. So we can
So
certainly.
Chief, you said for the police department, the must quarantine decision's already been made. Did you also make any decisions regarding testing when people return?
The testing was taken out of the draft that I had submitted. I had requested testing and some other procedures, but our legal counsel did not feel that that was appropriate and removed it from the.
I mean, wouldn't testing a negative COVID test allow somebody to come back to work rather than stay home for 14 days?
I think so, but you know,
they're not 100% sensitive though. That's the problem.
That's the argument is
positive.
Testing's not 100% accurate. So the 14 days, I guess if you wait and you don't develop symptoms, that's more accurate. But my question is, well, you could still be asymptomatic after 14 days, and I guess you could still be contagious depending on when you were.
Yeah, I'm not sure.
Help me out here. Are we coming up with a policy then only for the road department? It sounds like the police are doing their own.
Well, I don't think. Go ahead.
So are we doing one policy for all employees, or are we breaking it up?
You would have to, again, certain employees have exemptions that are in place by Department of Health, state guidance, and CDC guidance. So, you know, what extent do these exemptions have on the policy that you ultimately come up with?
Yet to be.
You have to talk to Lisa about that. I don't want to step outside my realm here and answer something that I can't answer. I can only discuss. Look, this is very confusing for everybody.
No.
You know, I'm just sharing what I've learned about this so far, and you know, there's an awful lot of stuff to consider. That's I guess where I'll leave it.
Absolutely.
Yeah.
Okay.
So Ralph, let's see if we can't get something on the calendar collectively Thursday or Friday morning this week.
Well, I'd like to just say something that's, you know, for the mayor, for discussions with the state government, for discussions among our on these county calls that we have. Well, I don't know where our borough is supposed to come up with 80 hours of paid leave for each and every essential worker on our staff, should they choose to travel out of state to one of these locations. We haven't budgeted for that kind of expense. So if we're expected to shoulder that by ourselves, you know, that's going to fall on our taxpayers.
Yep. Actually, they've been canceling. They canceled the county call tomorrow because there's nothing new to discuss.
Well, my concern is that, you know, we're being left out, hanging out to dry here, you know, with these kind of incremental expenses, unbudgeted now, because we just passed the budget tonight without any kind of expense, $0 to cover this kind of thing. I'm just concerned that this is a different situation than we previously evaluated back in March, early April, when we made the original decision. This is a much broader circumstance now, because these kinds of quarantines aren't coming from, you know, contact tracing that, you know, you had contact with somebody who has a positive COVID-19 test. This is a much broader brush. Anybody who goes to one of these 14 states or more suddenly is now going to quarantine for 14 days. That's a much broader swath of our potential employees.
Okay, thank you. Can we move on to 10C? I see Nancy's been on this meeting all this time, so she's still here? Are you still here? Yes, you are still here.
Yes, I am here. Can you hear me?
Yes. So you have given us a letter with the suggestion of doing a drive-in concert in September at the library.
Yes, and I actually talked with Chief Valentine today, just talking it through a little bit more. But because we won't be able to do any of our Sunday at 3 concerts in the library, we get somewhere around 60 to 80 people attending. We thought we would look at the concept of a drive-in concert. Our concerts are free. We would have people register their vehicle, and we would designate spots. And we do it either late September in through October would be the consideration. So weather generally good. And we would have to follow whatever guidance is in place at the time. If it was the same guidance as now, it would be social distancing, masks outside of the car. If we were doing every other spot in the parking lot, we would be able to put people in chairs. They'd bring their own chairs to sit in between the cars. We would generally do it when the library is not open or potentially close for that hour, close a little early on a Sunday, or do it, 4 or 5 o'clock on a Sunday afternoon. And it would be minimal expense for us because people would be using their cars. We would have a limited number of attendees. I mean, how many people are going to fit in a car? But it would be family oriented. Act, so we'd be expecting the mom and dad and maybe some kids, but it would be limited potentially to maybe a maximum of 30 cars, whatever would ultimately fit with whatever design we came up with. So we were looking for approval that this is something that we could proceed with the planning to hold this kind of event at the library.
Okay.
I like the idea.
Yep.
Yep, great idea.
Yeah, it's really similar though to the movies that the Boxcar's doing in the Bernardsville Center. I just as I pointed out in my email earlier to you all, if you're going to stream the FM through the car, like was the original proposal, we got to re-emphasize to people that they can't be idling their cars.
Yeah, we have to see if the FM's necessary. I like the idea that it would be windows open or you'd be sitting outside of the car as opposed to having to stream it in, but it's something we definitely need to consider.
Seems like you'd be close enough where, regular outdoor speakers might be sufficient.
Yeah.
Yeah.
But don't
And look, I mean, as everyone's aware, and we've been
closed? Sorry. Didn't the movie restrictions require the windows to be closed?
Yes, they did.
I think the difference though is they talked about parking in every other spot. Where if in the movie theater, I think they were parking the cars right next to each other, weren't they?
The movie restrictions had to do with in-car gatherings before they increased the numbers for outdoor gatherings. So once the outdoor gathering numbers increased, kind of negated the need for everybody to stay inside their cars as long as they socially distanced and you didn't exceed the number at the time. I think it was 200 and then it was 5. Now it's 500.
Yeah.
It wouldn't surprise me if after all the graduations are over, that number quickly drops back down again to what, I don't know. But, if we start to see spikes in this state consistent with some of this stuff that's going on across the country, I can see some of these requirements rolling back. So while I support the effort to hold this concert, I cautioned that we need to be very cognizant as to the size of it and to make sure that we're flexible so that we can follow any of the regulations or guidance that's in place at the time that may not be the same as it is today. So
yeah, I
have to kind of watch it closely.
Yeah, I think whatever we do here, it needs to. I think us trying to guess what the restrictions are not going to be in 2 months is probably not possible. So whatever we pass, I think it just needs to be approved by either the appropriate bodies that's consistent with the guidance of the state at that particular time.
Yeah.
Yeah, that's understood that we would have to be flexible because, as you said, we wouldn't know. We would expect, having a conversation with the act that we're considering, they probably have nothing booked themselves because of this issue. So it would definitely be with the understanding that we'd only be able to hold it if the regulations allowed it at that point in time.
Mm-hmm.
And plus, look, this is probably unlikely at this point, but maybe the restrictions continue to loosen, and you just don't know what's going to happen 2 months from now.
Yeah.
And it wouldn't be that big. I can't see it being, 100, 120 people would surprise me. I would think it would be closer to 80 to 100.
I mean, there's not even that many spots in the parking lot.
Yeah, if you have 30 spots with 4 people in every car, that's what I'm saying. I don't expect it would be that big.
Yeah.
And it would be restricted. We would definitely, you have to register, and if you don't have a spot, you don't have a spot, you can't attend.
Okay, are we all good with this concept? And we'll see what happens come fall with restrictions, yes?
But it'll be approved, it'll need to be approved by chief, same things as before, Chief Glenn Miller.
Well, that was, that's outdoor dining expansions. I mean, we haven't had to approve all outdoor activities, but I mean, I don't think that would be a heavy lift, to be quite honest with you. That's something I think we could facilitate and work with the library friends on. Jeff, is Jeff on still? I don't know if he's still here.
Yeah, but you were
Yes,
involved.
Jeff, yes, I'm still here.
So you think we could handle that, right, Jeff? I think
so, yes.
Yeah, I think it's fine to delegate that.
Okay, if everyone's okay with the concept, we'll let Nancy work with the chief and whoever else to make it work.
Thank you.
Thank you for staying up so late with us.
Yes, it's past my bedtime.
No, mine too.
Thank you.
All right, thanks, Nancy.
Bye-bye.
Bye. 10D, we have a request for a partial refund of the parking decal fee at the train station. This was for a couple, what was it, 3 months that they?
Anthony, did you find out if these people want to reactivate it in September? Was that the actual request here?
That was, yeah, originally they wanted a refund between March and June because that's when they did not use it. But then she came back and said it was really March to September because she's not going back to work until after Labor Day. So it was really from March to September is what she asked for.
This doesn't to me sound like the last one that you talked about, where the person had the annual pass, they returned the decal, they decided not to use it, and they were laid off.
Right. This is different than the last one that we had at a recent meeting. Yes.
So what is she going to give us the decal and then we give it back to her? I mean, that seems.
I think she wants to keep the decal. I think she just wants to get refunded for the time she didn't use it. So
we don't have a provision for that.
I don't think we were prorating them.
Yeah.
It wasn't going back beyond applied for the.
I mean, this is not a hardship request. This is, you know, they're not planning to use it because they lost their job or something like that. Is that correct?
I think they were just working from home during this time period.
Yeah.
Yeah, I didn't hear about anything about a job loss. It was just that they did not use it because they were not going into the office between March and September.
Yeah, I think that opens us up to a lot of this kind of requests.
Yeah, I don't want to set that precedent.
Yeah.
Well, I think the difference too is she doesn't want to give the decal back.
Right. She wants to use. She's going to go back to using it after September or after Labor Day. That's how she put it.
Yeah. No.
I would not be for this.
Yeah. No thanks.
Anybody else? Anybody want it? Want to give it back? That's easier to ask. So it looks like no. Okay, we're going to refuse that request. Okay, then we have a request for sewer user fee relief during tenant vacancy.
Well, I feel the same way. I think this is part of being a landlord and property owner. They don't have a tenant, but that's, there are lots of folks who are in a situation where they're not using something they planned on, and that's the world we're living in now.
Yeah, I mean, bad precedent for sure. And I think from what I read that their sewer fees for 2020 were based on their usage in 19.
Right.
The sewer fee in 2021 will be based on their usage fee in 2020, which will be low. So it'll be lower in 2021.
Yeah, so they'll actually get their money back next year.
Well, some portion of it, yes.
Yeah. So we say no to that?
I say no.
Yeah.
No.
Anybody say yes? Okay. Now we have inactive ABC licenses, which is one. We have one that's inactive?
We have two. We have one consumption and one distribution. So we have two.
Distribution is Claremont. Is that the?
That was the old Redevelopment store. It's now a JDJ General Store is what it's in the name of. That's the distribution one.
Okay, and the other Rudolph owns?
Is Rudolph? Yeah, he owns that. That's the old Thirsty Turtle.
Right.
License, but it's not for Rudolph Steakhouse. It's another.
Yeah,
license.
right, but he owns it. And are they paying for them, or are they not paying for them? They have to pay to keep it, right?
They still do pay the same fees for the inactive licenses. Yes, they've been paying that all along every year, the same fee that they normally would pay. If they were
Has
using
anybody requested a license? Anybody asked for one?
Has anyone asked for an ABC license?
Yeah.
They wouldn't really ask us. If they wanted an ABC license, they would have to contact the actual owner, and that sale is done privately, and then we would eventually know about it when they want to do a transfer, but they would go right directly to the owner, not come to us.
Yeah. Okay. Interesting.
Is there any benefit to the borough to maintain an inactive license for those two people who are now owners?
We'd have to pay for it, wouldn't we?
No, I think he just means in the borough in general for having them out there.
In other words, if we if those inactive licenses were free to be given to another company, we might be able to attract another restaurant, another vendor who would actually use it. Right now, nobody's using it, and it's of no benefit to anybody.
Well,
The decision is up to ABC, not to us. We can object to the renewal.
Well, I thought that was the question we were being asked, with whether we agreed with a non-renewal.
So I'm reading the from Amy Lee visit. Is that the correct thing to be reading right now?
Yes, she's from the ABC, right? Yeah.
She said if your town has a redevelopment plan or any way of connecting buyers to available licenses, would you like to give the licensee a tax break? Alyssa also mentioned that the town can object to the renewal of the license, but then you run the risk of the licensee appealing that decision. If the licensee cannot show good cause for continuing to stay inactive, then the license would be retired, meaning that we'd lose it outright. Is that correct?
Yeah.
Yep.
And then we would get it back if we wanted one.
Okay, I didn't realize we would lose it completely.
That's,
I thought that the vendor lost it, but there would still be, a number attributed to our town.
No, that's not so good. And I know the one that Rodolfo has, he is holding on to that, and the reason he gives when he renews it is I think he's hoping with the redevelopment that he
wants to sell it.
A second restaurant or a bar or something there. So that's why he's hanging on to it. I don't know about I know Drolleman's has been empty for a while, so I don't know why they have that one.
It's a distribution one, though, right?
Yeah,
that's on distribution.
That's not a restaurant. Yes. Yeah, that would just be like a liquor store or something. Could open up, but
So, is there any way that we as a borough could just kind of cooperatively help them find even an interim use for this license? I mean, there's empty storefronts. There seems like an opportunity here,
Well, he's interested in the train station. He's one of the people that's interested in the train
Yeah,
station.
but that's redundant, isn't it, Mayor? Because we're going to have the ability to offer that anyway.
Yeah.
Right.
Yeah.
So, I mean, I would be against giving him the train. I would be against giving him the train station because that effectively negates the fact that we even have an ABC license.
Yeah, I don't think he was aware of that at the time.
Yeah. Right.
Or you could make him give up the license if he wants the train station and say, okay, well then.
Right, you have to sell
your license.
it. Yes, well, that's a good point, Councilwoman.
If he gives it up, then we lose it. So
That's a risk.
No. Sells it to somebody else in town, right?
Oh, sure, if it's a willing buyer, yeah, but
Well, yeah, but if he only has a lease for 5 years and then he loses the lease at the train station, he's got to get out, then he's
right.
Well, he'd be much better off finding a place other than the train station.
Yes.
Then he can keep his license and everything.
If he's waiting for redevelopment, one, he's already on the redevelopment committee, which might be a slight conflict of interest. But more importantly, if that takes 5 years to get this stuff developed, he's just going to hold on to it for 5 years.
He's been hanging on to it for more than 5 years already.
He's paying for it, you know, I mean, he's.
Well, yeah, but
We're not getting the benefit.
yeah, our residents aren't getting the benefit of it.
No.
Jack, do you see any conflict of interest with a license holder being on a redevelopment committee?
No, I mean,
No.
I think the idea was to have different segments of the community.
Right. And so, I mean, he's a business owner. He has an
Right.
ABC license. We're interested in his input as much as anybody else's.
Yeah, it's an advisory committee too, so.
Yeah.
It's not like he's on the planning board.
I just wanted to ask the question because
Yep.
Yeah.
relevant point
It is.
being made there.
Yeah, but they get whoever's on the committee is getting their opinion listened to more.
But you know what? He never says a word. Did you notice
I've
that?
listened a lot. You're right.
He says nothing.
I have a question about this email.
Value add, but
What, Christine?
This email is a response to Anthony, but I don't know what the question was. Like, what is she responding to?
I'll pull it up. I just asked her what our options were. Let me take a look. Hang on a second.
Okay, that's enough. I get it now. Kind of.
So what do we want to do anything with this? Or do we want to?
I'd like to try and cooperatively work with him to say, is there something that you could do, even on an interim basis while you're waiting for the redevelopment, that would be an attractive use of this license that would benefit our residents? And, we're not trying to force him or make him do anything or whatever, but is there something that he'd be interested in? Maybe we can do it as a side conversation, Mayor, the next time we have our redevelopment committee, even.
Yeah.
You still have to go through the whole person-to-person transfer process and everything.
Right.
It's not easy.
When you say person to person, I'm just saying, ask him to use it, like put it into use, open up another place.
Oh, yeah, that he could certainly, yeah, that's not a problem. As long as he's still the principal. Then you'd have to do a place-to-place transfer.
how do we get these licenses to begin with, right? So like we've got, if there's another distribution license that's out there, we've got at least four.
It's based on population. You're entitled to a certain number of licenses per your population, but older towns like Newark and places are grandfathered. So that's why they have so many more licenses than their current population would allow.
Yeah. I'm like, Far Hills has like nothing. I mean.
No, they don't.
Yeah.
Not even one distribution place.
No. That's why we have four. They all come here.
Yeah, we have 5 distributions and 7 consumptions. Yeah. So we do have a lot. They were all grandfathered in before that.
Right. So if we lost the license, it would hurt us because we wouldn't qualify to get a new one based on our population.
It would hurt us then, you're saying?
Yes.
Yeah.
If we lost it, yes, because we have more than permitted under the current formula.
I think the current formula, we would have like 2 consumptions and 1 distribution, something like that.
You're right.
It would not be very many at all.
Yeah,
it's like
you're right.
one for, I think, every 3,000 for consumptions and 1 for every 7,500 or something like that for distribution.
Yeah,
so it's not a lot.
We have 2 distribution, Gary's and Adelphia, right?
No, we have the wine
Oh,
right.
56 Degree. We have Gary's. We have Berkeley Wine, and I think Monterey Gourmet has the other distribution. I don't think you can eat there. And
right.
And then the JDJ General Store.
Gotcha. All right. Yeah. Get them on liquor stores, I guess.
Yeah.
So her question in this email is, do we as a town have a way of connecting the license holder with someone who wants it? So what's the answer to that?
It would be great if we could publish that. I don't know if that's.
But it's really not, you're saying it's not.
It's private property. You can sell it just like you can sell,
Is the license though is it public information who has the license right now?
Oh, sure.
Yes.
Can we put that public information on our website so if there were new businesses in town, they wanted to try and buy a license?
No,
It's only available if he wants to sell it.
No, but I'm just saying the people would know who to call anyway.
But somebody in the restaurant business knows to.
Yeah, to call the ABC. They would know to do that.
Not an issue then? Wouldn't
I don't think so.
I mean, if someone were to ask me who if they're interested,
Yeah.
I would maybe I could give them the resolution.
Give them the information, yeah.
But I don't. We don't have that just out there on the website.
But I mean, it's good to know that Anthony, you could provide the information if someone called and asked.
Yeah.
Yeah, it's public record.
I like your idea, Tom, that maybe you and we have a private conversation with Rodolfo.
Yeah, I mean, maybe there's just something that, we could help with,
Yeah. Okay. All right. So where are we? Oh, mayor's update. Okay. June 24th, I was on the webinar. I think, Jeff, you were as well, the use of force policy webinar that was hosted by the Attorney General.
Yeah, I was on that.
Had a very impressive panel, and they talked about ways to address some of the issues with additional training. A lot of, I think you summarized it well in your email to your Public Safety Committee, but it's on the Attorney General's website if you want to just listen to that, because it was a really good program.
I'll send my summary to the rest of the council members.
Oh, yeah, that would be great. Thank you. We had our first Diversity Council meeting, the goal of which is to discuss our own biases and experiences, and then we are going to work on identifying and creating an action plan to address the challenges unique to our community. We have a meeting this Wednesday. I was going to try and meet more often, but I got this thing now, so I got laid up for a while. But thank you for your notes and get well wishes, but I'm one-legged now. We also had a call for action meeting with the freeholders that Chanel Robinson hosted, also to address on a county level what kind of policing policies we can do. And she actually said, which I did not know, we are 47th out of 50 states for use of force, for the least use of force. So
that's a good ranking then.
Yes, that's a good ranking. But they will be reviewing their policies, procedures, and programs. And they talked about bringing back the police academy on the County College campus. I sent you the complete count committee numbers. We had a meeting on June 25th. And then we've since had another one. We're dropping a little bit in our numbers. We were 3rd in the state, I think, and now we're down to 5th, I think, Somerset County. And Bernardsville's numbers are a little bit, we're kind of right in the middle of the county, I think. Terry is doing a great job of trying to get information out, and the next step is going to be reaching out to renters. So Jeff Price did a great job of getting us that data, and we're going to try reaching out to property owners to get the information to their tenants, so we get those census done. The Economic Recovery Task Force that I serve on for the county have submitted a report to the freeholders. One of the recommendations was that the county ask the state for some of the CARES money that the state received. So we'll see where that goes. The Recreation Master Plan, the survey is now up. The steering committee refined it and made corrections, and so that's now moving into, I'm not sure if they mailed out the paper copies yet, but the survey is available. And I did ask Recreation to appoint someone to the steering committee, and I'm waiting to get that name. Next Monday, we have our vision plan. So I guess we'll notice that meeting now for 6. And then we'll add to the agenda the Personnel Committee report on the policy.
I'll change that this week. I'll send it to the papers. Yeah.
And we did, we had a request from the school for the banners that we had up, and they are going to use them for project graduation tomorrow night. So they were thrilled to have access to those. And that's my report.
Mayor, Bob did send an email. I don't know if he was just updating me. Maybe he forgot to email you. But he was, Ted Dolan said that he would do it himself.
Okay. No, he didn't. I didn't get that. I know he said he was going to discuss it. So, okay, I'll add Ted to the list. And then the last thing, we have a letter from Senator Bucco, who wanted August, I believe, to be Overdose Awareness Month and asked if we would do a resolution to that effect. So if everyone is okay with that.
I think it was just one day. I think it was August 31st for.
Oh, was it? Let me just look at that.
It was a single day that he was talking about that would be annual.
Yeah. It was jumping all over. So are we okay with doing that? Yeah, August 31st as Overdose Awareness Day in New Jersey. If so, I will, Anthony will put it on the agenda for next meeting. Yes, good? Okay, do we have unfinished business? New business? Glenn. Hey, Glenn, how are you?
You're on mute, Glenn.
Didn't see you before.
Hi, Mayor. How are you?
Good to see you.
I've been on with no video. I just I wanted to take a minute just to say that as we start to go through doing these COVID policies for the borough, that we have to be careful with broad policy, as the police and fire and EMS are kind of put into a different scenario than the rest of the borough employees. People don't think about it, but the fire and EMS personnel are actually considered employees, are subject to the employee handbooks, as Lisa has made it perfectly clear to me over the years. And so as we pass these policies, I think we need to look at a medical oversight branch of this and testing, as we don't necessarily have to quarantine everyone for 14 days in the police and fire and EMS world. So I think it's just something that I wanted to bring up to the council, that as we move forward doing policies, we have to think about first responders being segregated and treated a little differently. And maybe we have to have some more aggressive approaches. We as the police have very strict requirements within the firehouse for sterilization and exposure policies. We've treated probably 20 COVID patients that we've transported. So, I mean, we're at a 0 exposure rate at, 20 to 30 exposures of residents. So, I think we're doing a decent job with that. The police have been doing a great job. But I just wanted the council to think about making it a very tight policy, and to watch making it broad what it has to do with first responders, and then also setting forth some type of a medical oversight should there be an exposure or be a quarantine need.
Glenn, would you and the chief actually recommend, and I'm hearing it, a testing and or different protocol for first responders as compared to other employees? I'm guessing the answer is yes, correct?
Yes, that answer is definitely yes.
Okay. And are there examples? I mean, obviously in Bernardsville, our exposure has been smaller, but obviously places like New York City and or larger metropolitan areas, do they have policies for first responders that are more appropriate, or that
They actually
you'd recommend?
Morristown Memorial actually has it for their employees.
Yeah.
And that's who does our medical oversight, where they have to have an interview when they come back to work after a trip, and then they're tested and they're monitored. We at the firehouse are actually taking everyone's temperature every time they walk through the door for any type of a meeting or any type of work night. So, everybody's got their own little, way of going about it. So,
Glenn, is it possible for you and the chief to propose a exposure response? It's not the right word, but propose one that you feel is reasonable. I've looked at them as well. I was just looking at one for a hospital in Philadelphia just last week, and it was testing after 5 days and daily temperature checks. So it was different. But if there's something that you'd like to propose, I'd like to entertain it.
I would defer to Kevin in the sense that his employees are paid and you're contractually obligated to certain things with them. But I certainly, Kevin and I have worked very closely together getting these policies in place. So I would just ask that if the policy is going to be made townwide, that we just make sure to insulate and isolate the first responders. And if there's discussions being had, if myself and Kevin could meet with the committee.
I would just advise, don't put too much emphasis on temperatures. 25 to 50% of the time, the patient's going to be afebrile.
Right.
Morristown it does put much more emphasis on the interview and on really thorough sort of reverse contract tracing, if you would. But I think the other question comes up: what test are you using? How are we going to sure we can access it? And then, of course, what's the cost?
And I think that's
what's the turnaround time for the test is the other thing. I think that Morristown is testing their incoming patients. Overlook is too, to my understanding, and they're doing rapid turnaround COVID-19 tests.
Yeah, I believe there's rapid. I believe that Morristown's using the Roche test now for IgG and IgM. And they are who we have our medical oversight with. So I just think it's something that we should just put a policy together, and I have no problem contacting them, or if Dr. Hammond wishes to contact them, just come up with some type of a set plan so that everybody's following the same plan in the first responder realm.
Yep, I think it's a prudent idea.
Yeah.
I think it's helpful too in the sense that it may reduce the requirements for 14-day quarantines if we.
Yeah.
I mean, I understand the tests aren't 100%, but I haven't heard that. It's one thing for the antibody tests are a little bit less reliable, but I was under the impression that the COVID-19 test itself, are you currently infected, is fairly reliable, Councilman Hammond, is it not?
Depends on which test you're using. There's a variety of them, and there's well been documented that people don't get positive until their second, sometimes even third test. It's not 100%. It depends on which one you use, and I know what they're doing for us as employees, but I'm not sure what they're doing for the EMS, Atlantic EMS. We'd have to find out. I would just mirror whatever they're doing.
That's a really good point. If we can take an Atlantic EMS, Jeff, and a relevant police department that's more populated than ours, citywide, I think it would give us a pretty good benchmark.
I can reach out tomorrow to Atlantic EMS as they share the COVID response with us. Okay. So I can get their policy in writing and get it over to the council.
Great, thank you.
That would be a big help.
Yeah.
Agreed.
All right, thank you, everyone.
Thank you.
Glenn? So we do have one more open session if anybody's still here and wants to talk. Do we have anybody?
I see some hands up.
No, that was Glenn's.
Terry's hand is up.
Oh, Terry, go ahead.
I just want to talk for a minute about census plans, because the complete count committee thinks that renters are not being reached, and so Mary Jane and I have worked out a deal where, and with the help of Leslie and Jeff, where we're going to put a letter into the tax bills for landlords with flyers in Spanish and English, asking them to contact their renters and ask them to, agree and fill out their census forms. And thank you to Jeff and thank you to Leslie for being so willing to help get us counted. That's all.
Thanks, Terry. Yeah, I can't believe how fast Jeff put that, Jeff Price put that.
I know, that was wonderful.
I know. It was really helpful. Anyone else? I think that was the last hand we had. I don't know. Do we have anything for executive?
I don't have any.
No, I don't.
Cool.
Chief Valentine, I thought he had something about a grievance, or is he signed off already?
Yeah, he's not here. Okay. Do I have a motion to adjourn?
Motion to adjourn.
I'll second.
All in favor?
Aye.
Opposed? Nobody. Okay. We are adjourned. Thank you.